My lord, I pray for my leave to mention, my lord, for one prosecution of the second.
Welcome.
Second.
Yes, all order 41 give. Give all order 41. Yes, wait. Wait. Order 41 give. All applications give.
Application.
All applications give. Just wait. Are you in hurry? Just wait let the application come. Yes, give all the extension of interim order. All give all the hearing matters. Now what is left? What?
For partition.
Hearing or what?
Hearing not. Application. Only application.
Don't mention. You have given an application, it will appear.
My lord, may we permit to mention one matter for inclusion, my lord? For inclusion.
For what? Inclusion of what?
The appellants, in spite of division.
I am asking inclusion for what? Application, order 41, extension, what?
For hearing, final hearing.
I said hearing, please give. Why you are mentioning?
May I have your lordship kindly to mention item number 6, Father. In this matter, your lordship was pleased to direct the corporation to produce the original death register. And we have brought it, my lord, the death register, as well as an extract of that particular page. May I place the original before your lordship?
Let it be called. Let it be called.
Actually, specially fixed matters are there, my lord.
So what? Let us see. Let it be called.
With my lord's permission, I'm mentioning one matter, my lord. It's for inclusion of a recalling application, my lord.
Sorry, rejected.
May I be permitted to mention item number 214, 217 and 282 of the daily list. My lord, the petitioner's advocate is out of station.
214.
214, 217 and 282. My lord, can it be taken after vacation, my lord?
Mention at the time of call. Yes.
May I have my lords kindly to mention a matter for inclusion in my lord's list. My lord, this is an appeal. Is an original side mentioning, my lord. There's some urgency in the matter, my lord. It's an original side, non-commercial suit, my lord. The learned single judge has proceeded to mark the matter for witness action.
Is it assigned or not?
Yes, my lord. It has been assigned, specially assigned. There's some urgency in the matter, my lord.
Give.
It's being kept for witness action on 12th, my lord.
Whatever, give. It will appear. Don't worry.
My lord, may I have my lord's kindly to mention a matter, my lord. The only issue is, I have given the slip. The difficulty is, if we had filed, only 1 second.
Which slip?
Well, order 41.
Yes.
Well, may I indicate the urgency?
What is the number?
But I shall indicate. But
What is the number?
449.
449.
But only one.
But
But there was a subsisting interim order in revision. Well, that order was recalled.
No, when I said accepted all the brief, why your persuasive appearance will make the list, the matter to a top? What for?
Kindly permit me to make one
your
sentence.
Why exhaust your energy on the day when this will be listed? Don't exhaust today.
Okay.
Yes, call.
I am appealing for the appellant, my lord.
Give.
Well, in this matter,
Let us see what is the report.
my lord, kindly see the last order,
Just-
26.
Date of death and- Why you are not giving a date of death and the necessary details in the application for substitution?
My lord,
Why you are not giving?
I have prepared a supplementary affidavit.
Sorry, so why you have not given?
My lord, I have done it. My lord,
Where? The report says on July you did not.
when the matter appeared, my lord. No,
14th of July, there is a direction of the Lavajima.
14 July, my lord,
Correct.
last matter appeared on 26th, and I have been mentioning the matter before the Lajim Court.
I do not know. There is a reporting which is done on 30th of August 2022. That is sorry, on 14th of July 2023
23.
says it is humbly submitted. Appellant was directed to take appropriate steps for incorporating the date of death and other necessary details that are lacking in the substitution application.
I mean, in
It
2020,
seems that the appellant is yet to take any steps in this regard. What does it mean?
my lord, I have,
Sorry,
my
you
lord,
will
the-
not.
my lord, kindly, my lord, in September, I have affirmed this affidavit after the
This
order
was
passed.
July. This was July.
My lord, I have been mentioning the matter. I don't even know when this matter has come out. September, last September, the matter came
Where
up.
is your?
My-
Why you did not file it in the department?
That I should
How
have-
the office will know
My lord, I have
that
been-
you have filed?
my lord, I have been mentioning the matter repeatedly there because there is nothing in this matter. My
File it.
lord. Actually, may I say what happened, my lord?
Nothing happened. Well, let the supplementary affidavit filed today be kept on record. Give me the application for substitution. The अरे substitution application दाओ.
Can two. Can two.
Respondent number 1 and 2 both died.
My lord.
Where are the names of the heirs you have disclosed?
Well, in the well, 12, paragraph 12,
What is
13.
this? 3?
Well, 3, it was for substituted service. That is because, my lord, one of the legal advocate of the legal heir approached me. I have stated that in my sub.
The application for substitution was taken out to bring the legal representatives of deceased respondent number 1 and 2 without indicating the date of death. The supplementary affidavit filed today reveals the date of death of both the respondents as 28/7/2020 and 18/8/2020 respectively. It is indicated that the aforesaid respondents died during the COVID period, and in view of the judgment rendered by the Supreme Court extending the period of limitation, the application for substitution shall be treated to have been filed within the period of limitation. There is no ambiguity in this regard, as the application for substitution was taken out on 18/2/2021 when the order of the Supreme Court extending the period of limitation was invoked. In view of the above, the application for substitution is allowed. The heirs and legal representatives of the aforesaid respondents as disclosed in paragraph 12 and 13 of the said substitution application be substituted in place and state of their respective deceased. Full stop. The application is thus disposed of. It is indicated that the learned advocate approached the learned advocate for the appellant that they have instruction to appear on behalf of the aforesaid legal representatives, and therefore the service of notice of appeal may be waived. In view of the above, let the copy of the application, any application is pending.
Yes, my lord, stay application, my lord, nothing
Let the-
remains in the state.
Correct. Let
Yep.
let a copy of the application being Can 1 of 2000, Can 1 of
16, my lord.
16 be served upon the said learned advocate who represents the legal representatives of the deceased respondents in course of this week. Can 3. This is an application taken out for effecting the service in substituted manner upon the heirs and legal representatives of the aforesaid deceased. Since the learned advocate has already since the learned advocate has approached the learned advocate for the petition appellant, and an order is passed herein above to serve the copy of Can 1 of 2016 upon them, the instant application has become infructuous and accordingly dismissed.
My lord, may I- one more indulgence. Let the application be listed. Nothing remains, but there is a stay.
We
But-
say let the Can 1 be listed
My lord, great.
in the next week.
That's ठीक. My lord, the answer is appearing.
Oh.
Substituted respondent.
Give. Have you filed Vogalatnama?
My lord, in this matter, I'm led by Mr. Shushanto Pal, my lord.
Will you file Vogalatnama or he will file Vogalatnama? Just tell us.
So, my lord, possibly Mrs. Ananya Niyogi will file Vogalatnama. Madam, it is. It has not been filed, my lord. Ananya Niyogi.
Let it. Leg it out. At the line upore likhe dao. What is your good name?
My lord, Guddu Singh.
Mr. Guddu Singh appears along with, what is the name? Ananya Niyogi.
Ananya Niyogi, my lord, and Shushanto
Ananya
Pal.
Niyogi, who had instruction to appear on behalf of the legal representatives of the aforesaid deceased, and undertakes to file Vogalatnama through Miss Niyogi in course of this week.
Grateful.
My lord, there are 3 items, 214, 217, and 282, for which the
What you are doing, sir? What for you have come?
to fix the date after.
What for you have come?
No, no, my lord, that is not called, my lord.
Call the next.
That 2 and 3, my lord, I am for the respondent.
Lord, I'm appealing
I
for
have
the
filed
appellant.
Vogalatnama. My lord, kindly have a look in the report, my lord. Perhaps the will has not come with the lower court record. For that reason, my lord, it has come before your lordship for lodgement. Matter could not be get ready.
OS 2 was renumbered to OS 5.
Seen the office note
My lord, only one thing.
dated 14/9/2023. And 12/9/2023 and 14/9/2023. Wherefrom it appears that the certified copy of the will, being Exhibit 1, has not been sent along with the lower court records. The office is directed to office is directed to take immediate steps for bringing the Exhibit 1 filed in OS 4 of 2010 and OS 5 of 2010 within 2 weeks from date. The London district judge, देखिए
Alipur.
High Court এর ফাইলটা দাও একবার।
Alipur. Huh? District Judge Alipur.
District Judge Alipur. London District Judge South 24 Pagna
Oh.
is also directed to ensure that the said Exhibit 1 is sent to this court within the time limit indicated herein above.
No, only one thing may I just.
Both the learned advocates appearing for the parties are directed to communicate this order to the London District Judge South 24 Pagnas immediately.
No, only one thing may I just indicate, my lord. This OS 5 was renumbered after OS 2 of 1999. Lord, the records of OS 2 has not come, but the records of OS 5, which was renumbered later, has come down. The OS 2 has to come, my lord. The initiation is of 1999.
So the moment it is renumbered, the file becomes segregated.
No, my lord, we have checked up the record. The order sheets of OS 2 are not there.
Nothing. Bring, let us see. Come ready. Argument. That's better.
Lord, that is important.
Okay.
OS 2 এর order sheet গুলো আসেনি, OS 2 এর খালি ইয়েটা এসছে নাম্বার গুলো, petitions গুলো।
Oh,
There are two.
oh, it was parted before the other bench.
Yes. No, my lord,
Why you did
no,
not
my lord,
put
not
Like-
parted, cancelled.
But it cancel one.
Kindly
Cancelled,
says, my lord,
but-
yes. My lord,
But
initially,
it has been assigned,
yes, that's assigned.
but it has not been,
No, my lord, I tell you, lordship, my lord, I was
Come,
from
come,
the very beginning, my lord, I was there. What
D'accord.
happened, I tell you, lord.
by our, কেটে দাও sir.
No, my
Our
lord,
attention is
logical
drawn to
logic-
the, এটা হবে FAT 127 of 2021. Our attention is drawn to the,
My lord, kindly sees, my lord, there
attention is drawn to the order of the Honorable Chief
তহব্রত
Justice.
চক্র না পাঠার
Where from it appears
কারণ তহব্রত চক্রবর্তীর ঘরে গেছিল, সেখানে এই প্রশ্ন উঠেছিল।
that both FAT 127 of 2021 and FAT 128 of 2021 has been assigned to the division bench comprising Justice Somen Sen and Justice Ajay Kumar Mukherjee.
না, না,
Order হয়েছে।
Stop. In view of the above,
assigned
let these matter go out of this. Look at it.
my lord, may I just take up the order?
My lord,
Please look at it. That's why I say I did not allow you to make any submission. Look at this order. Both at the top, 127, 128, at the bottom,
but by us and country, this is on 120.
let's call the next.
My lord, thereafter, my lord, this is the order, my lord, of the division bench, Topobroto Chakraborty and Parthasarathi Chatterjee.
We don't know, there is, the assignment has to be cancelled. If somebody has passed an order without determination, I do not know.
Transfer it to me. My-
Sorry.
My lord, let us come, my lord, tomorrow by checking.
Go before that. After this order, you can't.
কার ঘর, কার ঘর?
Assignment means.
এটা তো অফিসের স্পেশাল
Officers on special
রিপোর্ট
duty.
এটা।
128.
The last bottom is the main, that is a order of assignment. The name of the judges have been given. Next,
সাথে তারপরে রিটার ক্যান্সেল হয়েছিল কারণ এই যে Parthasarathi Chatterjee ছিল।
এটা গন্ডগোল হচ্ছে। My lord, I tell you, lordship, my lord, this after.
we will not hear, go there. We will not hear anything.
এটা চিঠি লিখে equipment check করো।
But
Really
my
চিঠি
lord, the Lojima,
Sorry, Lojima, I can't,
my lord,
Lojima court,
Lojima court, my lord, your lordship
will not take
having
up.
the
there's
jurisdiction.
nothing,
Will not take up.
nothing
Hey,
to do
the other-
with the application.
Stop, everything will be done from there. Yes,
Item 4, I beg to appear for the appellant petitioner.
why you beg? You have a right to represent your client. Why?
My lord, on the earlier occasion, your lordship was pleased to direct the constitution of a medical board. Your lordship would kindly recall it relates to the child
Yes, the constitution was done.
done, and
And-
they were supposed to file a report. My lord, probably that report is there.
Report. জন এসছে, চারজনের আমরা constitute করেছি. Why the two members did not come? Dr. Sujit Sarkel and Dr. Prashanto, Dr. Vidita Bhattacharya. Why? Why they did not? Yeah.
Your lordship would kindly recall, my lord, it was that matter where the child was in the custody of the mother.
No, I understand, but it appears that two members they did not. Why it will not be done by them? And there is no conclusive opinion which has been opined. They say that there are something which definitely needs further. I do not know in an appropriately equipped setup of any department of clinical psychology and the department of psychiatry of tertiary hospital with inputs from the pediatrician.
My lord, I was there, my client was there.
And
No, no, both were there. Father and mother both. Both were there. Their report says. Along with the child.
yes, yes. My lord, my client is also confirming that there were two doctors only.
No, no, they have said two members of the medical board attended. They have written. Why not four? Keep it at 2 p.m. A juvenile secretary, okay, Dako, member secretary. I think Lokesh. Let him come at 2 p.m.
But I'll inform the other side also, my lord. They were also there when the order was.
2 p.m. Na, actually, Dako na ke 2 p.m. में मैं टकरा था.
Mr. Shaktirat Mukherjee is leading us for the appellant in this matter. He's appearing virtually.
May it please your lordship, Lord, I beg to appear on behalf of the appellant. On the last occasion, the matter was adjourned to enable the parties to explore the possibility of a settlement. My clients, Lord, went to Mr. Jishnu Chaudhary. They had a meeting. Mr. Chaudhary possibly proposed to communicate some points to my client. We have written a follow-up letter requesting to indicate the points. We have not yet received any reply. Mr. Chaudhary may be here.
No, he's not here.
Mr. Chaudhary, we met Mr. Chaudhary. He proposed to communicate some point to us. We sent a reminder.
There was a meeting.
There was a meeting, Malad, and off.
He's saying that there was a meeting with Mr. Chaudhary. The
Yes.
meeting was fruitful. Then Mr. Chaudhary says that he will communicate through his client, from his client after taking instructions, certain points which need to be clarified or to be pondered upon. He says that till date, nothing has been communicated, though
Sent a reminder.
was given. Though the reminder was given.
Meeting 28 September meeting.
Why, if that is the position, you should disclose your stand.
Malad, on 28th of September, the meeting was convened in presence of Mr. Chaudhary.
Correct.
28th of September.
Whatever is the reason, but the order was passed on 13th of September.
Yes.
28th of September, after 15 days, meeting was convened. Just imagine, that shows the, the mindset, and that shows the jill, whether you are interested or not.
And nobody approached me for a settlement. So I do not know. Last evening I was told that no settlement has been arrived at.
And we wanted you to be there at least.
Nobody approached me.
Just imagine.
Nobody, other side, my client, nobody approached me.
My lord, if Mr. Mitro agrees, my lord, my client will get definitely. Mr. Chaudhary proposed, his junior.
Why is Mr. Chaudhary?
Where is Mr. Chaudhary? Why is he not appearing?
If Mr. Mitro agrees, my lord, I will send my clients immediately.
You have not sent your client. Nobody has came to me. They were
Going
last-
to Mr. Chaudhary proposed to hold it.
So what he's saying is that Mr. Chaudhary contacted and said that he wanted to meet. So his client has gone to Mr. Chaudhary.
Not only my client, his advocate also.
Anyway, so
Where is Mr. Chaudhary then?
at 2 p.m. inform করো কি যাবে বলো যদি কি আসতে বলছো আমি ওই যে তুমি যদি আসো না যদি should have been here.
This is not expected.
Malad, the meeting was convened in his.
I do not know. He wanted that he will. It may be a situation that if there is something, then they will approach Mr. Mitro. But nothing has come out. He says that yes, we have seen it. We'll have certain clarification, some points. We'll communicate that these points are the problematic one. Fair enough. But At least he will communicate what are the points, where is the problematic area.
My lord, may I say this, my lord? Lordship kindly keeps it tomorrow. My
Where is Mr. Chaudhary then?
lord, my lord, I am told, my lord, he's on legs. My lord, Lordship would kindly
2 PM rakho na.
make it not today, kindly keeps it tomorrow, my lord.
This
Alright.
is Mr. Mitro was there, and definitely when he was appearing, Mr. Mukherjee was appearing. So Mr. Mukherjee on that day, if I correctly remember, said, whatever Mr. Mitro will say, there is no difficulty.
My lord, the reason why, my lord, there has been a delay.
Then why Mr. Chaudhary intervened in the meantime? Why not Mr. Mitro was approached?
Because an email was issued by them.
That is all obviously.
Well, email was issued by them, hence, my lord, they all came to Mr. Chaudhary's. And
Whatever is the reason.
We were called by
Then-
Mr. Chaudhary.
yes, my lord, it was on 28th of September.
We were contacted that Mr. Chaudhary will be convening the meeting. We
Just
wrote this email
imagine.
to the advocate on the record.
No. It was not there, then Mr. Chaudhary will say, it is not expressed.
We wrote this email. Pursuant to this email, somebody from Mr. Chaudhary's office contacted us that he wants to sit over the issue. But we wrote this email on September 22nd itself.
Keep it for tomorrow.
Any day.
My lordship kindly keeps it tomorrow. I'll ensure
This is-
Mr.
this is
Chaudhary.
not expected.
Because my lord, the only thing, my lord, I'll be very honest to your lordship, why there was a delay. Because my lord, the defendant number 1 is in the custody, my lord. That is the reason why we.
But we
Well,
knew
Lordship-
it, we knew it. We knew it. On that day also, it was communicated. Then say that somebody is there to take care of that. Somebody is there to take a decision. There is no difficulty in this regard. And rather, if I correctly remember, subject to correction, Mr. Mukherjee was very, I would say, very candid in that you were saying that because of his client, you have been put into such embarrassing situation. But he says that if you say, I can help you out to come you out, to take you out. Whatever you want, he is ready to cooperate, if I remember correctly. So that was the situation. And then
Mitro
Mr. Chaudhary is not appearing.
My lord, lordship kindly keeps it tomorrow. I'll speak.
Look
to
at the embarrassment of Mr. Mitro. He doesn't know. And he was expecting that everybody will come to him. Why not? If Mr. Chaudhary was there, he could have taken everybody to Mr. Mitro's chamber. There was no difficulty.
My lordship kindly keeps it tomorrow. My lord, my lord, there has been some delay. My lord, we apologize
Sorry,
for that. My lord.
I think the role of all the advocate and record and the junior advocates are not appropriate. When the seniors, they say that I wanted to help them out. And this is how the juniors and the advocate and record behaves. And it's a fight between two brothers.
Yes.
So
My lord, kindly keeps it tomorrow. My lord, I'll. That's it.
It seems Mr. Mitro is agreeable to look into it.
yes, he says, and
I
really,
said
it is really a sort. It's a
It'll be-
sorry state of affair that he says that nobody contacted him.
My
He
lord,
was-
if Mr. Mitro gives a date below, I will send my.
No, that is you can, but the difficulty is his client. Because on that day it was understood that Mr. Mitro will sit and then try to solve. And then if the junior and the advocate and record, they take up the responsibility and do not give responsibility to Mr. Mitro, then what? Who is to be blamed? That's why I reacted. It's the conduct of the advocate and record and the other junior advocates. Why Mr. Chaudhary will straight away say that yes, I will help. the meeting.
My lord, let us have a chance tomorrow, my lord. I'll speak to Mr. Chaudhary also.
And he's busy in another court. Look at such a sensitive matter where the court really wants his, what he perceived, what happened, we do not know.
My lord, I was present on 28th, my lord, when the meeting took place, and I'm aware of the outcome. My lord, I can indicate the outcome, my lord. The offer that was indicated by the appellant before your lordship, my lord, that was not acceptable to my client, my lord. But if lordship, and it's the
No,
same.
no, say that it is not acceptable.
Yes, my lord, that will be indicated to them on that day itself.
Which one? Then Mr. Mukherjee says that, Mr. Chaudhary says that he
My
will
lord, Mr.
put
Sengupta,
certain
Miss-
points. He will put certain points means
yes,
it's
my
a
lord,
counter.
my lord,
It's a,
we had indicated, my lord, the offer
nothing.
that was made on 28th of September when Mr. Chaudhary was convening the meeting, or when the meeting was being convened, we had indicated that the offer or the points that they had indicated was, my lord, could not have been exceeded by us. It was not acceptable.
Nothing of that sort happened. Points were put and Mr. Chaudhary said that he will speak to his client and then.
No, my lord,
But nothing was
Look at it.
finalized.
no, my
Now
lord.
look at it.
My lord, I was present on that day, my lord. I can indicate.
I do not know when he's saying you were present.
I was there.
Look at it. Now we are not entering into this.
Yes, my lord.
It's better if Mr. Chaudhary.
Whom to be believed, whom not to be believed, we are not entering into this at all. Because we repose confidence on the members of the bar.
My lordship would kindly keeps it tomorrow, my lord.
The result of the meeting.
আমার কাছে আসি জিষ্ণুর কাছে
বলেছিল যে বেটা হবে না।
My lord, let it be dealt with by Mr. Mitra at that level. He will be able to dictate terms, will not bring about a settlement.
আমাকে বলাই হয়নি, বলা হয়েছে জিষ্ণুর কাছে না।
তাহলে বলে শুরু করে দাও, আমি শুরু করে দাও।
I don't know whether your lordship has been.
Start the matter.
It is Mr. Jishnu Chaudhary's.
We have understood. We have made certain
It has to
observations.
go, my lord, to the level of Mr. Mitro.
That is what Mr. Mukherjee is also saying,
Yes.
that Mr. Mitro can definitely
Yes, we bow down.
assert something,
Yes, sir.
whatever he feels that it is a correct one, that is
And I
acceptable to
thought
everybody.
That was the understanding, my lord, on the last occasion. But Mr. Mitro was not being, my lord, even I didn't.
No, that he says, and
So kindly
really,
the date where all of
he
us can go
he
to
is
him.
saying that he was not approached, and
Not
yesterday
approached, sir.
night he has been communicating.
Absolutely, yes. So it's better, my lord, your lordship fixes a date when both parties can go to Mr. Mitro.
Look at the conduct. Look at the conduct. Do you think that they have any inclination for
Settlement.
any settlement? They want a litigation. Let the litigation continue. We'll decide according to law. Let the litigation continue. What can be done? More interested in litigation, so let us. That has to be
My
decided.
clients were very interested. my
Parties
lord.
do not want my mediation. I am not going
No,
to.
no, that's true.
I'm
Mr.
talking on behalf of
Mr.
my
Mitra,
clients.
you
to
are
the level of Mr.
absolutely,
Mukherjee.
we appreciate your embarrassment. We appreciate your embarrassment. It's really an embarrassing situation
So
for
with
you.
leave of Mr. Mukherjee, I say. my
When
lord, my
everybody
clients were very
repose
interested.
confidence, everybody repose confidence on Mr. Mitra.
They do go on with this matter.
And then
Absolutely. But
his
they
part
are-
of a client or his advocate and record, look at their conduct. Even Mr. Mukherjee is saying today also,
Absolutely.
whenever is convenient to Mr. Mitra,
Absolutely.
his
my
client
lord.
is ready to go to
I
him.
am very eager to have a settlement, my lord. That's why I'm saying so. There is no difference between the parties. Really no difference.
No difference.
Everything is agreed.
Nothing.
কোথাও আমি রেডি আছি, মামলা করতে রেডি আছি।
তুমি আমাকে বলো না কবে যেতে হবে, আমি আই উইল মেক শিওর দ্যাট আমার ক্লায়েন্ট তো রেডি আছে, তুমি জবে বলবে তোমার কাছে যাবে।
আমাকে আমি নিজে থেকে ভলেন্টিয়ার করবো?
না, ইউ গিভ মি আ টাইম, আই উইল।
যাও অ্যাপ্রোচ করো, আসবো, আমি থাকবো। আমার বাড়িতে তুমি যাও।
From my side there is no problem.
Problem is from their
Yes.
side.
Yes.
The problem is from their side.
হ্যাঁ, প্রবলেম নেই।
Problem is from their side. That is the whole problem.
My client's representative is here, my lord. He is also agreeable to go to Mr. Mitra's chamber to, my lord, work it out amicably.
Why your advocate and record decided when on the last occasion it was decided that Mr. Mitro will sit and he will really apply its mind and whatever is, he take a decision, there is no difficulty.
And even after the matter, my lord, when we went out, that was the talk. That was the talk.
মামলা শেষ করলে কেউ করবে না, মামলা শেষ করবে।
My lord, kindly, my lord, Lordship would not kindly not take us. Otherwise, my lord, my client is here, my lord, his representative is here. I'll ensure, my lord, that he goes to Mr. Mitra, says that, my lord, we can, my lord, work it out amicably. My lord, Lordship kindly keeps it after some days. In the meantime, my lord, I will ensure that my client goes to Mr. Mitra and, my lord,
Who are you to ensure? If your advocate in the court does not,
no, I'll look into it that my advocate on
Look at it.
record ensures that my client goes to Mr. Mitra.
that was indicated to your advocate on record. And what is his role? And what is his conduct?
My lord, Lordship kindly, my lord, allows us this time, my lord.
Hey, Anindo, Mr. Mitra will kindly indicate a date here and now. What will be convenient to him?
বললো কবে, আমার কি অসুবিধা আছে?
তুমি any day,
বলো, চলো, আমি কি বলবো?
এই Saturday.
Look at is already preoccupied or not.
That's why I asked him.
Where is that?
Because I don't do, I'm not busy any longer. I don't want to be busy. I have plenty of time.
Where is the small one?
My juniors are very busy. Bhapi will be more, sorry, Mr. Chatterjee, difficult to find.
No, we are known for that. We know him like that.
আপনার
Yes, ma'am.
ডায়েরিটা দেখতে চাইছেন যাচ্ছে।
My diary is a Koda Kagaj. No, I don't want to be busy any longer. I don't.
No. Sunday, what time?
It's the Chatterjee suggesting Saturday, all right, Saturday.
Saturday, Sunday, whatever. Tell us.
Saturday, what time, bolo?
যেটা Saturday.
Oh,
Saturday.
no difficulty, no difficulty.
No difficulty.
Saturday, bolo?
তখন বল।
সকালে না বিকেলে বলো?
তোমার যখন তোমার
আমার
সুবিধা।
সকালে এটা 11টা করতে পারো, বিকেলে হলে 5টায় করতে পারো।
সকালে 11
11
Saturday 11 যেটু
I'm noting it down.
Saturday 11
জানিয়ে দিও।
Saturday 11
Okay.
I'm noting it down. If you want
even Mr. Mukherjee can be present, my lord, online.
Online.
So
yes.
both of them,
That's
my lord,
right.
can
Online. That's right. I talk to him directly.
That will be,
air communication. And that will be much better for all of us, my lord, that both the best minds can sit together, my lord, and find out all.
Mind বলে কিছু নয়। Willing mind, not best mind, willing mind.
that was really
intention.
the impression which was given to the bench on that day, that both of them will be able to sort it out.
Absolutely. Absolutely.
Should we record what has happened?
No, please
With
don't,
certain kind of an aspersions?
I know,
My
don't.
lord,
Lordship kindly, my lord,
Echo. The meeting held with Mr. Chaudhary does not appear to be concluded, to have been concluded. Stop. We, on the last occasion, we indicated that Mr. Mitro and Mr. Mukherjee may be in a position to bring a peace and harmony into the dispute between the two brothers. Mr. Mitru, sorry. However, they could not sit
My lord, may I?
for the reasons unknown to any one of us. A further suggestion came that if both Mr. Mitru and Mr. Mukherjee interacts with the respective litigants, there is a possibility of a solution to a disputes ongoing between the two brothers. Mr. Mitru, then a senior advocate, volunteers in this regard and communicated to the court that if the parties intend to interact with him, he is ready to sit on Saturday, give a date at 11 a.m. Mr. Mukherjee, the senior advocate, accord his consent in this regard and also volunteer that if necessary he may be allowed to participate during interaction on a virtual mode. We appreciate the initiative taken by the senior counsels and therefore adjourn this matter for fortnight with an intent to encourage the settlement of the disputes with such process. We are not recording mediation process, but anyhow, process. Let this matter be listed after fortnight.
Under the same heading, Lordship. Under the same heading.
Extremely grateful.
Grateful, Lordship.
Thank you, Mr. Mitra. Thank you, Mr. Mukherjee. Yes.
order, then my lord kindly hear the matter. Kindly see the last order passed by your lordship.
তোমার নামটা দিয়ে দাও।
এখানে সামনে আসো।
নাম দিয়ে দিন। এটা দেখো। আমাকে বলবে তো তুমি। এই যে কে ঘোষ ওকে বলছি
আমার তো বলা কথা জানিস তুই।
Yes,
Kindly see the last order passed by your lordship before proceeding further in this matter.
disposed of under the heading for orders.
Yes. No, not that part. Kindly see the first part.
Yes. We have seen that.
Yes. Now, my lord, what happened by this time?
Now, whatever, we have said that there was a dispute with regard to the
Now
certificate.
corporation authority
Now
issued
the
the death
corporation-
certificate.
Corporation we wanted. Who is representing the corporation? What do you have said?
Hey, this is the, your
Yes.
lordship was pleased to direct to bring the death register. We have brought it.
What is this?
Death certificate, my lord. By pursuant to your lordship's direction, we have applied before the corporation for supply of the death certificate. This has been supplied. Copy the.
True. It is now. Correct.
Yes.
So what does it mean?
My contention is correct.
What correct?
That my lord, the person died in 1964.
The
তোদের কি বলতো মানে মৌরি তো ওই জন্য নামটা আগে লিখে
দাও।
দাও। Now may I just remind your lordship what is the matter, my lord, if your lordship. Now second thing, my lord, second thing,
we will
Yeah.
not go. Let us first see.
599.
What about your original
599.
panchayat? We have directed you to file the original.
yes,
Serial number 599.
কবে কার record করো? 17 date of death.
এই petitionটা বার করো।
Professional cerebral hemorrhage. MRB hospital. MR Bangalore hospital. Certificate.
এই ডেথ সার্টিফিকেটটা পেয়েছি সেটা।
আচ্ছা, নেই। না, না, ও তো হসপিটাল আমার বাবু আর এটা হচ্ছে রেসিডেন্স রেসিডেন্স প্রিভিয়াসলি আচ্ছা গিয়ে এখানে এটা বসন্ত রায় রোড
May I read column wise?
No, we can read up to column A9, but I do not know 10. Oh, that is Amar Bangar. He died in the Amar Bangar. Correct. No, we can read it. There is no difficulty. Where is your?
Now another thing, may I kindly see, my lord, this supplementary affidavit because this has been received yesterday. What দিচ্ছি তো copy দেখ। Number what?
I don't get to see, Malad. I'm just having the copy, Malad. I cannot. No, you
Take
received
the
yesterday
instruction.
means affirmed by whom?
My lord?
Is affirmed by your client, same.
Yes, yes. No, this is, my lord, kindly see the second supplementary affidavit. What happened, we also filed an application under the Right to Information Act before the Panchayat Authority, since when they are permitted to use the death certificate. Reply came, my lord, kindly see, surprisingly, shocking. আরে ওকে দে না কপিটা। এই তো দুটো দিয়েছি তো তোকে, কি বলছিস? এই তো হাতে দিয়েছি, পড়বি না তোরা?
এখন দিলে কিভাবে?
রোজকেই দেখ, আমাকে দেখার দরকার নেই। আরে উল্টো পাল্টা করছিস, তোদের কি দিতে বলছি দেখ, এইটার আগেটা পুরনো। এইটা আরেকটা কপি আছে দেখ। Since 1997, they used to issue the death certificate, and now kindly compare the death certificate which was filed with the plaint.
No, we wanted the original first. Where is the original?
I took the instruction from my client. My client said that he has not filed this death certificate before the court below. And he does not possess this death certificate.
Show me from
ये कॉपी कहाँ से आया? उन लोग के ऊपर का लॉयर जो दिया उससे तो लोअर कोर्ट में ये मिलेगा ना? ये डेथ सर्टिफिकेट हम लोगों का वो नहीं फाइल किया। मेमो है पीछे ठीक है पीछे। अरे फालतू बात मत कर। But they are saying they have not. Kindly see paragraph 4. Kindly see paragraph 4 of the plaint.
what we are saying, page 31. We are indicating, I am indicating to my brother.
See, when your lordship asks the original, now we have not filed. And kindly see, my lord.
Now tell us,
On the basis
do
of
you have the,
Aadhaar card.
do you have the copy of the Feristi?
No, my lord, the documents which are annexed that has been received from the learned advocate, I kindly turn to my lord, page.
We will not leave. Don't worry.
Page 80.
May I
Hey, he is very innocent. We will not leave. If he has committed a forgery, we will not leave anybody to walk so merrily.
Kindly see page
We'll
14.
record. Don't worry.
Kindly see page 14.
We are calling for the entire record.
That will
Don't
solve
worry. Not solve the problem, sir. That will really create a lot of problems to your client.
If my client is at fault, then my client
You have-
has to suffer.
You have managed.
Kindly direct dispensing with production of the death register.
Sir,
But, if that be the situation, then I am apprehending. Kindly direct the judge.
just wait. Pursuant to the order dated 13 September 2023, the Kolkata Municipal Corporation produces the register, the death register maintained by them. It appears that the said Paresh Chandra Singh, sorry, the factum of, it appears that the factum of the death of said Paresh Chandra Singh is recorded in serial number 599. In the register containing the details of the death of a person between 30th October 1964 to 4th January 1965.
May I file an extract of that document?
It's not necessary, sir. Why you are interacting?
No, for future reference.
Mr. Das, this is not for. Only thing is they produce this document, whether the genuinity we wanted to. Yes. What I said? It is shown in therein that the said Parashchandra Sen died on 14/12/1964 at M.R. Bangur Hospital. And the date of registration is shown the same date, shown as the date of death. First up. By the said order, the respondent was also directed to produce the original death certificate issued by Prangonjo Gram Panchayat, which was filed before the trial court. First up. The learned advocate appearing for the plaintiff respondent submits on instruction received from his client that the said death certificate was never filed before the trial court, nor his client is in possession thereof, and therefore the question of filing the said certificate cannot and does not arise. It is a serious matter where two death certificates issued by two independent authorities are filed before this court. A link can be seen from the averment made in the plaint, where the plaintiff respondent in paragraph 4 disclosed the date of death of the said Parashchandra Sen as 1/1/1985, which was shown in this death certificate issued by the said Gram Panchayat. In order to have more clarity on the stand of the rival parties, on the stand of the plaintiff respondent, let the record pertaining to title suit number 526 of 2023 pending before this Civil Judge Senior Division Second Court at Baruipur be brought to this court. The learned district judge is directed, district judge, the South 24 Parganas is directed. No, sorry. The Registrar General of this court is directed to immediately contact the district judge, South 24 Parganas, over telephone, so that he shall ensure that the said record is immediately brought to his chamber and chamber for onward transmission to this court. The aforesaid exercise shall be done before 12:30 p.m. Now, so far as the contact and the bringing of the file by the district judge shall be completed within 1 p.m. today. The record shall be sent immediately so that it reaches to this court before the next date of listing. List the matter on Thursday. Let the supplementary affidavit, let two supplementary affidavits filed by the appellant a copy whereof has been served upon the learned advocate for the respondent court today, be taken on record. The Kolkata Municipal Corporation is directed to take back the register produced before this court, and their appearance is dispensed with for the time being, unless warranted in course of the hearing. এই রেজিস্ট্রার জেনারেলকে ইমিডিয়েটলি ডাকো, এক্ষুনি ডাকো, ওরালি বলে দিতে হবে। বলো to meet at 12. শোনো,
My lord, I am appearing for the appellant. Here, my lord, one of the respondent died in the meantime. Therefore, my lord, substitution is necessary for bringing, my lord, one Chapa Pradhan, one of the respondents. Therefore, my lord, I am praying, my lord, let it be taken up next week.
representing her.
No. Mr. Asim Kumar Rai is representing me.
I think this matter was argued at length because I
Yes. My lord, that was but 10 days back she died. Therefore, my lord, I am praying let it be taken up on the next week. In the meantime, my lord, I shall file substitution application and serve upon the said proposed days. Chapa Pradhan.
Champarani or Chapa, whatever.
Chapa Rani Pradhan.
Champarani. That is the respondent number 7.
Champarani.
You are for appellant.
I am for the appeal. Last 10 days back, my lord, she has died.
During the hearing of the instant appeal, it is pointed out by the learned advocate or the appellant that respondent number 7, Srimati Champarani Pradhan, died 10 days ago. And therefore, an application for bringing the legal representatives is required to be filed before the court proceeds with the further hearing of the instant appeal. In view of the above facts, let this matter be listed after 2 weeks to enable the learned advocate for the appellant to take an appropriate steps.
My lord, this is our appeal, my lord, from a decree for partition, which is the question of whether a settlement.
Final,
Yes, settled that settlement.
preliminary or final?
Preliminary, that issue of whether your lordship has to construe whether that is a deed of settlement. Oh, that issue. My lord, my leader, Mr. Basu, is not here. You have read the judgments, but kindly accommodate me once. Tuesday, we'll come back. You have considered your lordship's judgment another time. I am for the appellant. Kindly take it up on Tuesday. We have considered your lordship's judgment, which your lordship and our other.
Consider my judgment.
No, no. Kindly keep it on. He was addressing your lordships. Kindly keep it on.
Where is he?
He's not come to court today. So I don't know. Kindly, we want to finish it this way or that. No, he's my junior.
Which was the respondent?
I have spoken to him. He's the advocate.
Joint Gray, get this matter straight on the next week.
Deep-
Two B to two D.
My lord, I'm appealing for the appellant, my lord. My lord, kindly gives me 1 second. My lord, we need to check the report once, my lord.
One.
My lord, one. My lord, sees my lord's order dated 19th of July. The heirs of different number, respondent number 1 initially appeared. And then the my lord said that they will not be appearing. My lord sees my lord's order dated 19th of July.
19th of July.
Yes.
There, respondent number 2A and respondent number 2PCD.
They appeared. Well, kindly see.
I just wanted to look at whether the service is complete or not. As far as the one is concerned, I do not know whether it.
Well, one, well, kindly checks that order, 19th order, well, point number 2.
Oh, that's true. What about 3 and 4?
Well, 3 and 4, we had put in requisites in terms of Mullard's order dated 19th.
Here there is no track report, service report of the donor has not yet been received.
In fact, Mullard, they are the heirs of the person for whose non-joinder, Mullard, my partition suit was dismissed.
But they are the very necessary, they must.
Yes. So, Mullard, we already filed the requisites in terms of Mullard's order. Yes, Mullard.
But the service report is not here, so we don't know whether the service has been affected.
In fact, Mullard, there was last order of my lords.
Seen the report dated 8/9/2023. So, 8/9. It appears that the notice of appeal was sent through speech pause
but the service report has not been received. Office is directed to submit a further report. On downloading the information from the official website of the India Post in course of this week. With regard to the status of the service effected through speed post. This is the matter on next Tuesday.
Grateful, my lord.
Yes.
Here I am for the respondent cross objector. Lord Rabindranath Datta is for the state. And my lord, Mr. Dhamali and Ayan Banerjee for South Bengal. They have filed separate cross objection. I have got cross objection.
Oh, Mr. Govindan is appearing for the appellant in 130, item number 130. Mr. Ravindra Narayan Dotto is appearing for appellant in item number 130.
Yes.
131 is filed by somebody, Free
Yes,
India
I-
Dry Accumulator.
I am appearing for the 131.
131, you are appearing for
Cross objector. Respondent cross objector.
cross objector. And 132,
Mr. Ayan Banerjee is appearing
South
for
Bengal State
Managing
Mr.
Director, South Bengal.
no,
State
Devoshri,
Yes,
the
Devoshri.
Dhamali.
She's the advocate on record.
Yes. Argue. We are dismissing the main appeal, but cross objection,
I'll be praying for an accommodation.
no. This bench was not there. You had 15, 20 days time because at least I went to the circuit bench at Port Blair. So you could have get yourself, this matter was taken up before my departure. He was insisting that the matter should be taken up. And Mr. Romina Samant Dotto, if I correctly remember, he says that I do not know, he has not been there in the panel now.
No, now he is
Now says that he has been
now he has been specially engaged.
engaged. So
He appeared on the last occasion two
then
times.
Mr. Dhamali has to, we are dismissing the appeal then.
Then I have to, if, it is
Your lordship
better
would
that
kindly grant.
Now, whether the dismissal of an appeal will survive the cross objection, let us see.
we have to argue.
Let us see. My gut feeling is it should, but let me. The appeal is withdrawn. Yes,
133 last minute. After vacation, my fine.
yes. No, no.
Sorry, sir.
এটা না এটা না আপনি পরে 133 না এটা 132 পর্যন্ত
We are coming,
My lord, in this matter, my lord, Mr. Rabindranath Dotto was the appellant on behalf of the state. My lord, at present, he is not in the panel. My lord, it is difficulties,
Last time he says that he has been.
special engagement, my lord, engagement not yet been done till today, my lord. My lord, it is,
Then he is not there. You will dismiss for default. Let it be done.
my lord, my lord, give me some times, my lord.
How many times? This is continuing since last.
My lord, it is the last chance, my lord. That
Continuing with the last 2 months. An appearance is made on behalf of Mr. Rabindranath Dotto. It's an advocated record in FA 20 of 2019. And the submission is advanced before us that he is no longer in the panel of the state of West Bengal. And the last officer, it was communicated to us that the special appointment in the instant case service done in his favor. But today it is communicated that no such letter of appointment has been issued as yet. As a last chance, let this matter be adjourned till next Tuesday.
এই যে আমাদের appearance
এটা লিখে দাও. It is however made clear that on the next date, if such special appointment is not made, it will be deemed that the state of West Bengal is not interested in proceeding with the instant appeal. And the court may proceed to dismiss the same body. Communicate this order.
That I am for not today kindly, my lord. Today kindly, not today, my lord. My lord, I am not ready properly today.
We are ready, you are not ready.
Next week, my lord. Kindly
Sir,
next
we are ready with the matter. Please
Kindly.
argue the matter. Not a single appeal is taken up by us since morning.
Kindly.
Everybody is asking for adjournment. How long will it continue?
Kindly no.
Then we will not take up the hearing matter. It's not, I think nobody is interested in doing the hearing matter. It is better not to take up the hearing matter. Unnecessarily, why we should? There are other Order 41's applications. Will take up those applications. Order 41.
Then, my lord, after vacation. My lord, only not today I am praying before Lordship.
Sir, only word is a very ambiguous word, sir. Last week also, I mean, when it was taken up, only not today. Today also, only not today. This only word is very vague. It's the litigant who suffers for this. What can be done? You are not ready. You says you had enough
I
time to
feel so
get
uneasy.
yourself
For
ready.
that I am not ready.
Sorry, it's really unfortunate that the member of the bar is not ready with the matter. It is submitted by the advocate on record that he is not ready with the matter, and therefore the same may be adjourned. List the matter after 2 weeks. Yes.
My lord, in this matter, my lord, I am appearing led by Mr. Ashit Varun Raut, my lord. Give me short passover, my lord.
Why?
My lord.
You are appearing, you argue. Start.
My lord, the I am
For the other
appealing-
side,
My lord, I am appearing for the, my lord, defendant one, appellant before your lordship and petitioner before lordship. My lord, it is required, my lord, additional evidence, my lord. My lord, some documents, my lord, later on, we have received, my lord.
did you file an application
No, my
for
lord,
it?
kindly give the, my lord, leave, my lord, I am praying leave, my lord, to file the
Why, what you were doing,
My lord,
this appeal?
document, my lord. the
Why
should
you did not file it earlier? What you were doing for so long? Today you are saying some additional documents. This was known to you much earlier.
No, my lord, later on, when we are, my lord, searching the document, my lord, we are got,
Searching the documents.
my lord. the
When you
client
filed
handed
the
over-
appeal, you did not search the document. How you prepared the memorandum of appeal without searching all the papers?
Later on, my lord, the document we have received, my lord,
When you received the document, much earlier.
after filing the, my lord, memorandum. of
Correct.
appeal,
This
my lord.
appeal was filed in 2021, sir. Entire 2021, 2022. Now we are at the fag end of 2023. What you were doing for so long?
This document is very much necessary, my lord, to.
I
actually-
understand. Then why you did not take out an application earlier? When the appeal is matured for hearing, then you are coming and taking this plea.
The issue is here, my lord, the it's very much necessary, my lord, to adjudicate.
We don't know, but we can't appreciate that you were sitting idle. That is what is our concern.
I'll kindly give the, my lord, to file.
Will it not give a sense that you wanted to avoid the hearing of the matter?
No, my lord.
You wanted to just gain time?
My lord, the issue also, my lord, the main issue we are raising in my lord, the written statement in the court below, my lord. That issue also not been framed, my lord.
Maybe, but you knew that you led an evidence on that issue.
Well, in connection that issue, my lord, the document is very much.
I am asking you, sir, did you lead evidence on that particular issue? Did you lead evidence or did you not lead evidence?
I have given the, my lord, evidence, but
So-
the document not, my lord.
Maybe, sir,
exhibited-
when you knew that this is the issue, may not have been framed, but you knew that this issue is there. You lead evidence thereon. Can now, mere non-framing of an issue is so fatal. I'm asking you this.
My lord has the power, my lord, to grant these leave, my lord, to file this application, my lord. To additional evidence, my lord, it is required, very much required, my lord.
Sir, there are a judgment galore of our High Court, even one I know of the Supreme Court is there, which says that non-framing of an issue is not fatal if the parties knew well that this is an issue involved in the suit and they had led an evidence thereupon. Then it is absolutely an academic. It is no longer a very fatal one.
My lord, if the documents is not, my lord,
You had an opportunity to lead that evidence. These documents were available to you at the time when you deposed in the trial court.
no, my lord.
No. You don't know.
The document, my lord, later on I have received, my lord, from my client, my lord.
Actually,
Kindly leave, my lord.
It appears that he's not interested. What interim order they are enjoying?
Partitions at the time of the appeal. And come to one.
No, what interim order they are enjoying? In this suit, only interim order is not to pass a final degree. That's all. Nothing. That has to be when a preliminary degree is there. Even if we lift the interim order, if the final degree is passed, then if this is interfered with, then what will happen? That will also fall. Problem is here. Partition commission work has been completed. Be done like this.
Right, 2014, 14, 14, 2014.
2014?
Appeal, these appeal.
Appeal is of 2014 or 2021.
Final order, final number was given to 21.
Oh. What you were doing?
My lord, kindly give me.
No,
my
no.
Lord, my lord, this document is very much, my lord, kindly.
Sorry.
Kindly see the
Sorry.
document, my lord.
Nothing.
The main issue, my lord, the original owner was, my lord, Narendranath Das was the original owner, my lord. My lord, he died living, my lord. So far, our document is, my lord, concerned, my lord, 3 sons and 3 daughters, and widow. And my lord, the plaintiff in the court below, they raised the question that the Narendranath Das, since this is has the my lord has the first wife, my lord, and from the said wedlock, my lord, the one daughter is, my lord, there, my lord. But my lord, no evidence, my lord, no documentary evidence, nothing is there, my lord. My lord, in that family member, my lord, of Narendranath Das, my lord, they filed one, my lord, preemption case, my lord, against the defendant appellant before your lordship. And there, the averment that, my lord, the Narendranath Das was 3 sons and 3 daughters only. So, my lord, the daughters, the previous, my lord, wife, my lord, there is no existence, my lord. The family member, my lord, disclosed that, my lord, in the my lord, preemption case. So, my lord,
Who is he?
learned court below, my lord, are this point.
Who is he?
Third party purchaser, my lord. Stranger, third party purchaser, my lord. I am also third party purchaser, my lord. But the family member of Narendranath Das, my lord, disclosed in the my lord, preemption case that the Narendranath Das died leaving only 3 sons and 3 daughters. My lord, that document, my lord, we have got recently, my lord. So it is very
What recently? When recently? 2014 matter, when the preemption was filed.
My lord, 1985.
So
against that, my lord, the preemption case was, my lord, dismissed. Against that, appeal was, my lord, misappeal was prepared. There was also, my lord, that averment, my lord, recorded, my lord.
So what happened to the first appeal?
3 sons and 3 daughters.
What happened to the first appeal? What happened to the first appeal?
First miscellaneous appeal.
Yes.
My lord, dismissed.
Then revision, any revision?
No, my lord.
No. Then
no record is there, my lord. But the averment, my lord, in the my lord, preemption, my lord, application as well as in appeal, my lord.
and in
all
this,
those documents are
in this, what they have disclosed, Narendranath died with 3 sons.
no, my lord, they are taking the plea that Narendranath Das died leaving 3 sons, 4 daughters. But no documentary evidence is there, my lord. So, my lord, this document is very much.
Did you say in your evidence that it was only 3 sons and 3 daughters?
Yes, my lord.
Did you say
Yes, my lord.
that?
And also,
what the court has held?
My lord, also my humble.
What the court has held?
3 sons and 4 daughters.
And the share was 1/7.
Yes. Yes, my lord, no issue also framed.
The issue is immaterial. If the party knew that this is an issue, there is no difficulty. You lead an evidence on that.
So, my lord,
So
additional,
what?
additional evidence is,
Nothing.
my lord, required, my lord,
Nothing.
to adjudicate this point, my lord.
Who was a party? Whether their predecessor was a party?
Here.
In that preemption suit?
No, the preemption suit was filed against my client. One sons of the late, my lord, Narendranath Das filed against my client.
Are they claiming right through that Narendranath? Are they claiming right through Narendranath? Having purchased from 6 years
Yes, yes, my lord.
or 7 years?
They have purchased through the legal years of the Narendranath.
Oh, how many? 6 or 7? I just wanted. They purchased from 6 legal representatives, 6 years, or they purchased from 7 years. I just wanted.
Seven years, my lord.
They purchased from 7 years. And this 6 also joined. How is that? তুমি বলছো 6, ও বলছে 7, যা আছে ও ডিলে যা আছে 7 জন বিক্রি করেছে, কিন্তু অকিন্দ্রের পুরো শেয়ারটা ওর কাছে এসেছে। That is it.
Kindly allow my senior, my lord. Kindly allow.
So many complicated things are there.
Show us. This is one of them. We understood. No problem. Second, sir, the answer is very simple. Answer is very simple. They claim the entire share of Nagendra or Narendra, whatever. What is his name? Narendra or Nagendra?
Narendra. N-A-R-E-N-D-R.
Yes, the original name of Swami Vivekananda. So no difficulty. Narendra. They purchased it. They claim the entire share of Narendra. Whether they acquired from a 6 years or a 7 years is immaterial. It is a Nagendra share which will come to them. 6 of them has joined, which you are admitted that he is there. He has 6 years. One extra person has joined, immaterial. This will be valid for the purpose of the entire Narendra share.
We are my client is also purchaser, stranger purchaser.
Sir, a stranger not from Narendra's side.
My lord,
Sir, that's why I asked your junior that have you purchased from Narendra's heir? He said no. Even a Narendra's heir filed a preemption application against you, claiming that you are a stranger purchaser and therefore they are entitled to a share. That's all. And this preemption application was dismissed. He said that in the preemption application, the heirs they said that Narendra had 3 sons and 3 daughters. That's all. You did not acquire any of the share of Narendra.
Yes,
No.
I have purchased from Narendra's here.
He said from Narendra 7 persons have said.
No, I'm telling you, Lord, see, my lord, only dispute with regard.
আপনি বুঝলেন আমি জানি না, আমি
My lord, only
বুঝেছি।
my lord, I'm telling you, Lord, see, they are also stranger purchaser. I am also. I have also purchased from the one of the heirs of Narendra. And my lord, I have purchased on the basis that Narendra had 1/6 share. 6 heirs are there. But according to the no 7. First wife was there.
But they have purchased also from all these 7 years.
No, my lord.
That is what their claim is.
No.
No means?
My lord, they have. My lord,
No means what?
My lord, kindly allow me to place the plane.
I think so many lawyers are present. I
Why
think
don't
my understanding may be wrong.
No, my entire.
I asked a very specific question to
I
your
think, my
junior,
lord,
whether you have acquired any share of Narendra. He says no. Narendra Ray in turn filed a preemption application against him.
Well, that is the given, but whole thing, I have,
Whole
I,
thing-
well, I have also purchased the Narendra share and they have also purchased.
Sorry.
And I purchased on the basis that Narendra left 6 years. 1/6, on the basis of 1/6 year, I have purchased. And according to them, no,
Sir, whose deed is earlier?
deed. My deed, my deed on different, they have also purchased by 3-4 deeds.
I do not want to know. I just say whose deed is earlier.
My lord, so far, এই দেখো তো আমাদের deedটা বলো। আমার just a minute. আমাদের deedটা দেখো। I think I am the first purchaser. But your lordship, kindly take up after application, my lord. Very
Is it a
complicated,
case that
very complicated facts are there.
no complicated? You peoples make it more complicated. There is no complication. Is it a case where Narendra, please? Is it a case that Narendra has a vast land? Some of the portion of the land or the portion of the undivided land is sold to you and other portion of the undivided land has been
My
sold to them.
Yes.
Is it that case?
My lord,
I just want
if your
to.
lordship kindly see,
My lord, only,
what
my-
was their stand in
no,
that-
my lord, kindly allow me, my lord, kindly 1 minute.
You are, that is a whole problem nowadays I am seeing amongst the members. First thing is that first you have to ascertain, you being a plaintiff, filed a suit for partition against him, obviously treating him as a co-sharer or co-owner of the entire property. Now, how you treat him as a co-sharer? The first and foremost thing one has to understand.
my lord, as per our case, we say that we have purchased, my lord, 1/8 share. Out of the, my lord, what Narendra has sold to us. My lord, kindly see, my lord, kindly come to my plane, my lord. My lord, in 1960, what happened in this case, my lord? There was a first wife, there was a daughter.
My lord, yes, yeah, my lord,
No. First thing is what share Narendra had in respect of the entire joint property.
Enter property.
Was he an exclusive owner?
Yes,
Or
yes.
he was
exclusive owner.
he was an exclusive owner. First disclosure must be to us is that what is the total area of land, extent of land which he owned exclusively.
My lord, what they committed wrong, one thing, your lordship, according to them, Narendra had first wife. And they have purchased the share of the years of first wife. Well, that is the absolutely absurd totally. There was no first wife, no daughters.
First, let me ascertain, sir, till time I am again saying, you peoples are really creating a lot of confusion.
My lord, we are not.
No,
First thing, let me ascertain what is the total extent of land
Which Narendra.
which Narendra owned and possessed. What is that?
My lord, now, my lord, prior to that,
Total.
only one clarification, my lord, I will, my lord, give, my lord. My lord, that, my lord, in their written statement, they have denied the factum of the first marriage altogether.
We are not going into
We
first and
30
second marriage now. Sir, let us, that is the whole problem.
My lord, kindly come to the plaint, my lord.
I just wanted to know the total land which according to you
My lord,
is
there were
undivided.
different deeds, my lord, number of deeds, my lord, through which it was.
I do not,
Different
sir,
plot of land.
please show me a scheduled property is the total land.
Yes, in the plaint, my lord, will get.
It contains an area of 0.05 decimal.
Only it is the disputed land only. Only disputed land, 0.5 decimal.
What is the total land?
Total land, total land,
There are where number of land.
Disputed land is only 5 days.
The partition was sought for, my lord, only this 5 decimal of land. So the other plots, my lord, of land, my lord, which are there, my lord, there is no dispute about that, my lord, share or.
No, this is the total 5 decimal of land. So 5 decimal of land was owned and possessed by Narendra.
Narendra.
No difficulty. Now total area is 5 decimal. Now out of this, what your deed shows, the entire 5 decimal is sold to you, or you have been sold a lesser area than 5 decimal. What is the stand which you have taken? Very simple thing. Let us understand.
I would kindly come to exhibits 6 onwards, my lord.
How much, according to your sale deeds, in total, how much you purchase out of 5 decimal?
My lord, it starts from page 156, 151 of the paper. Because there were, my lord, other years, my lord, from after the date of Narendra, my lord, we purchased from them also. Their sale. One from 151, my lord, it start the first deed, my lord. Here I have purchased, my lord, out of kindly come to the schedule at page 157.
Here's from your deed that from your place that he is you are a defendant number 1 or plaintiff?
No, we were the plaintiffs.
Plaintiff. So you have said that a defendant number 1, they purchased the share of 2 daughters of Narendra by the second wife. That is Gauri and Parvati.
Yes.
And is occupying a northwestern corner of the said plot. First. So they say that 2 shares of Gauri and Parvati. And then the defendant number 2 to 3, you are also representing them. And defendant number 4 to 6, where the heirs of another daughter, that is a Basanti Pal. Basanti Pal appears to be the daughter from
The
first wife. No, Bhavani is the
Bhavani.
first wife. Basanti is the
Second.
third daughter of the second one. And defendant number 4 to 6, they sold the property to you by
Defendant
a
number
sale deed of 2006.
2, 3, 4,
So if their stand is also taken to be correct, then this Basanti was also one of the daughter according to the admitted position. That's an admitted position
Yes,
because
yes.
they say 3 daughters
Yes.
from the second wife.
My lord, my lord.
So this is what is there. So Basanti's right you have claimed. So you have acquired this right.
No, it says,
Then-
my lord, my lord, Gaurian Parvati and is occupying the northwestern corner of the suit plot.
Sir, you have also, I am looking at your plain, sir.
From the plain.
You
I
have
am reading,
said
my lord.
paragraph 6 that the defendant number 1 purchased the share of 2 daughters of Narendra from second wife Gauri and Parvati and occupying the northwestern corner of the plot. Secondly, other heirs of the Narendra, Vijaya, defendant number 2 and 3, and Advaito,
4
and
to 6.
defendant number 4 to 6 were the heirs of another daughter, Vasanti. The defendant number 4 to 6 sold the property to plaintiff. Means the heirs of Vasanti sold the property to you. Third, no difficulty, and delivered possession thereof. And you are in hegemony possession of the purchased land. Share of Advaito was transferred to a third party from you purchase. So you purchase the share of one of the son
To a third party, my
and
lord,
then
from whom I have
purchase the share of Basanti. Defendant number 3 sold his share from his father to plaintiff. So 2, 1 has sold to him. Now 2 remain.
Defendant number 3. Defendant number 3 here.
Sir, 3 sold to you.
Yes.
No difficulty. 2 remain.
By inheritance from his father.
The defendant number 2 remains. You have not said anything.
Yes, my lord,
That is a Radha Govindo.
my lord, defendant number 2 and 3 and Advaito. Now Advaito, my lord, transferred to
Or
a third
sir.
party. His share, my lord, from Advaito.
Not third party. He's transferring, you purchased it.
Yes.
Let us go by this. So you acquired the Advaito's share. You acquired the share of one of the daughter, Basanti. Correct? Then you acquired a share of defendant number 3 also. Defendant number 3 is Dulal. No difficulty.
So far this share is
Second son. So 2 sons and 1 daughter has sold to you. Ultimately, you got their share. So 1 you said that sold to them. No, they purchased it from Gauri and Parvati.
Gauri and Parvati.
3 sons and 3 daughters.
Can he purchase the share of 3 sons and 2 daughters?
पता है. So you purchase really from all the 3 sons and then 2 daughters. But
As well
you
as
have said that the 2
other-
daughters, Gauri and Parvati, sold to them.
My lord. So far that they are purchased from that 3 sons. That is disputed.
What is?
There was no first wife.
Yes. The
Narendra money.
first wife had a daughter only.
No, my lord, no, this is the my lord.
that will be
My lord,
adjusted
that's it.
Sir,
My lord, this is our case. We have taken specific stand in our. The Narendra had only wife, only 1 wife.
My lord, that is negated
Only
by
one
my lord exhibit 13.
Only 1
My
wife.
lord, their stand.
understand, sir. Let me understand first. So I am unable to find out defendant number 2's share, where it has gone.
Defendant number 2. Defendant number 2.
Radha Govind.
Radha Govind. Radha Govind. My lord, if your lordship kindly come to page 94 once, my lord.
Oh, you have said that you have also purchased Radha Govindo, Advaito and Basanti. One at by purchase and from Bhavani. According to you, Bhavani being the daughter of the first wife, you have purchased that. Correct.
Now comes to page 94.
Page
94 of the judgment. The share distribution.
What was the document which was produced that she had a first wife?
Exhibit 13, man.
Page running page.
My lord will also find from the evidence of DW 3, man, at page
Where?
21.
Page
21.
Whose evidence it is?
This is the evidence of my lord, 3, different number 3.
Dulal.
Yes.
Yes. What he says?
He says, my lord, Dorenda said,
Which page? That is the additional written statement, page 21. Where is the deposition?
my lord will find that page 56. Well done.
That is the plaintiff's evidence. Where is the defendant's evidence?
Defendant number, my lord, is page
He's
49.
called as his witness. Witness number 3 for the plaintiff.
My lord, 46.
46, he is a third witness. Your third witness.
'61. Page 64. DW 1.
No, I was insisting upon DW 4. My lord, DW 4 also says, my lord, there were 2 wives.
Who?
DW 4.
Fourth witness.
Yes.
Who is he?
My lord, he is villager, my lord, village person, my lord.
Which page?
My lord, page 40.
What 40?
No, no. তারা একটু ডিফেন্ড নাম্বার 4টা দেখুন তো কোথায়?
There is no fourth witness. Third witness.
Yes, মানে page 49. My lord, kindly come to page 50. He was the witness in the deed. And my lord, the second paragraph is starts, the name of the first wife of Narendra is Komola and name of second wife is Sonoka.
Which one?
My lord, page 50.
50.
My lord.
This is whose evidence?
But this is
a fourth witness. Your
I'm relying upon that, my lord.
what?
DW4.
Yes. But DW3 is also a villager.
Yes, DW3. DW3 হচ্ছে
And he has denied.
DW3 has denied, my lord, of the second marriage. He is
Where
not
is
a
the
villager.
where
He
is the examination in chief of this witness? Number 3. This is at page 76.
My lord, defendant number 3, that is one of the sons of Narendra. My lord, he has stated, my lord, there are 2 wives. There is a daughter from the first wife. DW3.
What has been said in the deed?
Exhibit 13, man. Exhibit flow,
dispute is ওটাই দুটো বউ ছিল, একটা মেয়ে ছিল, একটা বউ ছিল না হাসব্যান্ড। ছেলে
কিছু দিতে হবে আমাকে। হেল্প হয়ে যাচ্ছিল। ইন্ডেক্স তো কোথায় দেখবো আমি? কোথায় আছে? এক্সিবিট এখানে লেখা থাকবে?
What about the deeds? In his deed and in your deed, what is the reflection?
You also kindly allow me to place my written statement. What is your stand? So far, first wife is concerned, we have emphatically denied. There is no first wife. And according to this, they have purchased one share from the heirs of the first wife's daughter.
Only dispute is whether there is any existence of Bhavani or no existence of
Yes, man. Only yes, man. Gratefully, only.
Let's see. That's why we wanted to know. That's all.
I mean, the family members' evidence has not been taken into consideration. Outsiders, on the basis of the outsiders' evidence, the Ranner Court Bilas County concludes. So, for the existence of the first wife.
Sir. Dependent number that the PW1 is one of the member. He's a son of Narendra.
My lord, your lordship kindly come.
Now he's a son of Narendra. Radha Govindo, what is that? Nanda Gopal. He came and deposed.
My lord, so far Radha Govindo is concerned. My lord, Radha Govindo is concerned. We are disputing. Radha Govindo
you are disputing.
Page
Did
one
you-
eighty-eight. Radha Govindo is not the legal heirs of Narendra.
Hurry,
Page 188. Malad the exhibit 13. It is the deed between.
Nando Dulal is the son.
Yes.
And the Nando Dulal has said that my father had two wives.
Sandhya.
So- Nando Oche is a PW3. Son of Narendra.
Maybe to Bhavani. Sorry.
He's the son of Kenaram Das. No.
Sorry.
Kenaram Das Oche.
So far, Radha Govindo is concerned in his preemption case. He has Malad categorically contended that the Narendra died leaving one widow, 3 sons, 3 daughters. Malad the application of preemption and the entire proceedings, your lordship kindly allow us to put.
What is the inter-recital of the deed? Sir, both of you are not ready with the matter.
My lord, we were ready, my lord, but it has gone, my lord.
What gone? The recital may be one of the best piece of an evidence.
My lord, DW4 who is a co-villager, he was categorically stated, my lord, there are.
But the DW3 is also a co-villager. He says no.
Yes.
Whom to believe?
No.
And
It's the question of oath to oath.
And Malad, one of the
My lord,
legal
he says he was,
case.
Sorry.
my lord, he says he was not present at the time of marriage of the, my lord, this Narendra, the second marriage of Narendra.
Show us.
My lord, kindly see page 47. I was not present at the time. Oh, no.
Show us from the deed anything that will come out.
Oh, yes, yes. My lord, page 188.
188.
Nimnoto, my lord, may I read, my lord? Nimnoto.
Vikrita is Dulal Das.
Yes, Devabrata Sen and
And
Dulal
this was done when 2010.
10.
Yes.
Now the second paragraph, ভবানী মাতার মৃত্যুর পর আমার পিতা ঠাকুর মাতা সনকা দেবীকে বিবাহ করেন। তাহার গর্ভে আমি এবং আমার 2 ভাতা রাধা গোবিন্দ অদ্বৈত এবং 3 ভগিনী যথাক্রমে বাসন্তী, পার্বতী, গৌরী জন্মগ্রহণ করেন। এবার তার তৎপর পিতা।
And where is their deeds? Executed by Basanti.
আমাদের শুনতে পারে।
Yes. Where is their deed?
সবই তো আমাদের
261, 261, 261.
तीन धाता
বিকৃত সম্পত্তি সূত্রে বক্তব্য অন্য বিনা আপত্তিতে
And your lordship will find from 262. Second paragraph. Here in this manner, the deed it has been clearly stated. 3 sons, 3 daughters. Each having 1/6 share. And accordingly, we have purchased 1/6 share. Another T that pays 269. Executed by Fargo.
Yes, conclude after two. Conclude it.
Your lordship, complication is there, Mala. Just now he has handed over a document. Kindly go through.
Just now is not there.
Next. Mala, kindly give us that.
Any document, new document you are relying.
I'm not letting you go through. Preemption case was there. Kindly next week, Mala. Next week.
Next week.
Come at 2, we'll
No,
discuss.
Mala, next week. Mala, kindly make it. Mala, because before vacation, your lordship. Before vacation, your lordship.
Before vacation? No.
All right, Mala, next week. Next week.
No.
Next
Your lordship.
Next week, 10:30. Next Tuesday, 10:30.
Nothing.
Yes.
May I place the defense case made out in the written statement, relevant paragraphs? What is our case actually?
What to do?
It is our specific case.
Specific case now, whom to believe, whom not to believe.
Your Lordship, so many witnesses.
Not to believe.
The heirs of the Narendra, they came forward and deposed.
No, deeds are there. Yes. 160. Their deeds are there. 160. And the deeds they have indicated very categorically.
In my deed also, Your Lordship.
It was executed by the daughters.
Yes.
Now all the sons and everybody has said marriage.
No, so far the Your Lordship kindly consider they have miserably failed to establish before the court below that Narendra had the first wife. And the learned
Who said did not have a first wife?
The legal heirs of in the written statement, Your Lordship,
From the deed it appears that they have executed and said that yes, Narendranath has two wives.
They proceeded on the
Death of one. From there they had one daughter.
Yes.
Bhavani.
Yes. And Bhavani died leaving one son and one daughter.
They have executed a deed.
But the fact remains, he had no first wife. No first wife.
Question is whom to believe?
The preponderance of evidence.
Preponderance, then what?
Well,
should it go by a quality or should it go by a quantity? Tell us.
Quality and Your Lordship consider. I'm telling you, if your Lordship.
If you say quantity, you are out. Because the maximum number of the years they have said 8.
No, so far their witness is concerned. They have not uttered. Only their recital part of the deed. So far my case is concerned, not only it appears.
Recital.
In my also deeds, Your Lordship kindly have a recital.
What I'm saying.
I have done.
Mr. Rao, my question is whom to believe and whom not to believe. Tell me. Then what should be the parameter? A deed executed by the sons, deed executed by one of the daughter, one daughter from the second wife, admittedly your sister, and third one is by somebody who also claims to be the daughter of Narendra. All these deeds were categorical, saying that yes, Narendra had two marriages. From first marriage, one daughter, and from second marriage, 3 sons and 3 daughters. In your deed, it says Narendra had 3 sons, 3 daughters. This is a conflict. How to come to a conclusion? Who is trustworthy? Who is not a trustworthy? Tell me under the law, what is that?
The heirs of the first wife, my lord, will be trustworthy.
So far Your Lordship,
let him answer.
Consider the evidence.
Who is trustworthy?
Trustworthy, Your Lordship, find from the materials on record.
The problem is, neither you have brought any of the heir of the Narendra, nor they brought any of the heir of the Narendra. Now question is what? Had it been that either of you brought one witness, we can understand that we will go by that. None of them. Now, you brought one villager, he brought one villager. Both versions are absolutely diametrically opposite. Now, whom to believe? And it appears both have a very, the age is very in a close proximity. Now, sir, how to resolve? Tell us.
What is the law on this subject?
Mala, in coming to the conclusion as it appears from the impute judgment, the learned trial judge has placed reliance upon a particular deed, Exhibit 30.
No, I am again saying, sir, there are 3 deeds which are coming.
My lord.
3 deeds are in their favor, saying that there were 8 heirs at one point of time, because the second wife was alive. So 8 heirs. True? One deed came from you, which says no.
Well, my 2 deeds.
2 deeds. Suppose 2
Parvati
deeds.
and Gauri.
Oh, correct. They say no. There were only 7 heirs.
And Mala,
Now, question is, whom, again I am coming, repeating. Now, what should be done? It's a question of belief and disbelief.
disbelief.
Nobody has come forward. Only thing is, both of them are relying on a deed. And particularly the recitals in the deed. Recital is a very important
My lord.
part of
It's
the
all part
deed.
of the yes.
Very part. Now, both of them. Now, the question is what to be done.
My lord. So one that Mala preemption is concerned, case is concerned, which is not before Lordship.
Again,
Well,
I am
as it
saying,
appears,
sir,
One
again,
of the sons,
okay, the Bhavani was not there.
no power.
Now, the question is, Bhavani,
Bhavani, actually, Mala, I'm telling you, Lordship.
I am telling you, Bhavani has also, I mean, the heirs of Bhavani has also executed.
No, Lord.
Now,
Bhavani
question is,
Bhavani son
they
and daughter.
said something. They said something in a preemption proceeding. But they have said something there in a registered document. And there they could not prove the preemption. Their case was turned down. They could not prove. It is very risky at this stage to go by that.
So that preemption proceedings.
Very risky. How? Somebody could not succeed. Had it been a case that they succeeded and the court has held, yes, then the question would be that once the judicial pronouncement has been done and where it has been declared that they are the 6 persons, then unless those judgment and decrees set aside by Bhavani or their heir saying that it is wrong, this will continue. But they lost. They could not. That's why I say this is not material additional evidence. Not material at all. Because they lost in both the courts. Then how to go by it? If one view has been accepted, relying on a particular deed, maybe there is another view possible. But that doesn't mean that the judgment of the trial court is perverse.
Well, next year, Lordship, kindly consider one thing. Whether the plaintiff has been.
There are possibility, 2 views. Both has a very weak piece of evidence. Both. Even if as an appellate court does it invite the appellate court to interfere when both the views are possible? Then in that event, one has been accepted. No, sir. Very difficult.
My lord.
Very difficult, sir.
Lord, let us think over the matter once again. Well, kindly take our next Tuesday. Kindly allow me to think over the matter in different way. Kindly allow us. Kindly allow. Your Lordship has take trouble to go through the entire Your Lordship. Kindly give us a chance. Kindly. Next Tuesday,
bad,
at 10:30.
Bad judge, but
Mala,
won't be a bad.
No, kindly.
We will not
Kindly go through. Kindly have a second thought over the matter.
We will not adjourn them.
And Your Lordship, kindly have a look. Plaintiff has been miserably failed to prove his own case, as it appears from the evidence. As it appears from his cross-examination.
Then we talk law. Suppose if there is a variation in the documentary evidence, which is a public document, and in the evidence, which will prevail?
And in that case, documentary evidence
So-
will be no doubt.
So
But
there is the documentary evidence.
Well, so far the documentary evidence, you also kindly consider my deeds also.
That is what I'm saying, sir. Are you,
Eh?
you are going
My-
square,
my
you are
deed is-
going back to the square one.
No.
I am again saying, sir, there is a difficult situation. There are two sets of deeds which are coming before the court, where the recitals are somehow just opposite to each other.
And only
Now,
the,
question is, what to do in such situation? What to do? I'm again going square one. Which deed has to be believed? Which deed should not be believed? Let us go to that step. What is the law?
Mala, only one thing, since they have purchased the property from the heirs of that.
No, they purchased the property from Nando Dulal also. They purchased the property from Radha Govinda also.
My major portion they have purchased from the heirs of that daughter of first wife.
No,
Yes, my lord.
no. They, what are you saying? We have seen those deeds. All the sons, Advaito, Nando Dulal, Dulal, and
Dulal.
the Radha Govind. Radha Govind, Baina, there was a Baina Patro. There was a suit with before the civil court. They succeeded in getting the decree, put the decree in execution. In execution, got the deed executed in their favor.
Yes,
Now,
that's
three sons have sold to them.
and
One daughter, who is also standing at par with you. Out of three, one daughter has also sold to you. And all these deeds says that, yes, the Narendra had two wives. From first wife, Bhavani was there. Then he got, when he purchased from the heir of Bhavani,
yes,
the share.
yes.
Now,
Well,
this is what is their part of the story. Your case is, no, two daughters from second wife, they sold. They said, no, there were no first wife, no heir. I am the two of the daughters out of six. My mother was also there, so I have 1/7. We are giving you 2/7 here.
well, in that
Now both deeds are here. What to do now? Question is very important. Whom to believe and whom to disbelieve. Now, what is there is no evidence at all. Rather, I would say there is nothing. They stood firm, saying yes, there was a first wife and there was a daughter. You said no, there was no first wife. These are the only wife and these are the sons and daughters. If this evidence has come, then what to do? Tell me.
Bhavan is yes, my lord, they have also admitted, my lord, that.
I have seen that, sir. I have said that, Bhavani. Now, in this scenario, what to do?
Then one thing your lordship can do, send back the case on demand.
What for? What evidence? Now tell me. I can understand. What evidence? You have to say, we have to record our finding that this evidence is lacking. This evidence should come. Tell me what evidence. So question is that considering this aspect, a view has been taken by a trial court, which cannot be said to be because he believed those deeds, which cannot be said to be a perverse. The question is, we can take a view, no, your deed should also be considered. There are two possible views. Both views are possible. Whether the appellate court should interfere with the judgment and decrees only on the ground that there is another possible view. I am asking this, putting this question to you. I know some judgments against you, where the apex court has said that if there are two possible views, if one has been adopted by a judge, then appellate court, even if he thinks the other possible view is there, should not interfere with you or a judge. Now what to do, sir?
But the documentary evidence is concerned, no doubt, the recital.
No evidence at all, sir. Both. You have cited 3, they have cited 3 or 4. It is not a number of the witness.
What it is earlier, 1980.
It is not a number of the witnesses. It is the quality of the evidence which is very important.
9 deeds on me, 2 deeds on you.
That's why I asked whether the quality or a quantity.
That's true. But my lord,
Obviously not a quantity. It has to be on quality.
and my lord, apart from that, my lord, you also kindly consider the evidence of the respective parties.
We have seen this. We have read the evidence. The evidence is very categorical. Sir, forget about any aspect.
But there will be all the outsider or stranger have come forward to depose on their behalf.
No, they came forward. They brought, I think, one of the Bhavani's heir.
Bhavani's daughter's grand son. He had no direct knowledge.
It's a lineage.
He had no direct knowledge in my opinion.
Whatever. So that is what I am saying. And you have not, you came forward, you brought it, nothing more than that. And one villager, no, I know that Narendra did not have.
So far my witness is concerned, I have purchased from Basanti and Gaudi. Gaudi's husband came forward and deposed.
Correct. That is what I'm saying. Then the Bhavani's grandson also came. Both of them. The difficulty is how to assess.
And your lordship find from the written statement, given number 23, they have supported my case.
True, but they did not prove it. They did not prove it. They did not come forward. They did not adduce evidence. The problem is this. There is a distinction between a pleading and a proof. Mere pleading will not tantamount to proof.
Until and unless it's knowledge.
Correct.
Let us go through your kindly.
Page 270.
81, my lord.
81 or 85?
My lord, page 261. My lord, page 261 and another
I
269.
can't get a date. 81.
My lord.
Anyhow, deed number. And when the suit was filed,
When a suit was filed.
preemption,
Preemption. 85.
and when
Second January 85. And my lord, as page 254, your lordship will find another deed. One brother executed and sold the property in favor of two sisters. There also declaration is there.
who? One brother means who?
My lord, would not take it up. My lord, kindly come to page 254. Gauri and Parvati. Gauri and Parvati sold to Aditya. Advaita.
Also sold to us.
All right. Well, in that deed, your lordship kindly have a look at the declaration. Between the brother and sister, what was the declaration in that deed? 254. Maybe subsequently it was sold. Your lordship kindly have a look to that. Well, 255. Maybe it was subsequently transferred. My lord, next page 255, middle portion. Well, here it has been declared 1/7 share. 3 son, 3 daughter, and wife.
Wife died prior thereto. Wife died in 1980. I mean, Sanka Devi.
My lord, that's true. My lord,
So 1/7 means what? 3 sons, 3 daughters, then 1/6.
1/7. Narendra died, wife, 3 sons, 2 daughters. And accordingly it was 1/7.
Means 3 sons, 3 daughters from Sanka. The wife was there, so 1/7. Wife was dead before that execution. So how? If the wife died intestate, then her share will default upon 6. So it will be 1/6.
1/6.
But they say 1/7 because they recognize Bhavani. And this is what Advaita, after this purchase from the sisters, sold 1/7 share to ultimately it came to them to Camilla. Shushanto purchase is sold to them. So this is what is the 1/7. Sanka died in 1980, sir. These are the deed after that.
Yes, she died at it.
So, and in 1984, she says 1/7. She should say 1/6. Why 1/7? No, sir. Sorry.
My lord, that will, my lord. That will.
ये হচ্ছে third sister থেকে ও টানছে বাসন্তী দেবী। Then what happened? Aditya, Adwaito, he purchased the share of 2 sisters. So he has 3/7 share. But he sold 1/7.
No.
Then what about 2/7?
My lord, he sold his share to Sushanto. Thereafter, Sushanto, well, by 2 deeds, he sold to this, my lord, present, this, our defendants one, a plaintiff's one.
Shushanto also purchased by 2 deeds.
Yes.
No, Mr. Ram. Sorry.
My lord, only one thing, Your Honor, 277, my lord, the record of right.
That is LR.
Yes, my lord.
And interestingly, the name of Gauri is gone. The name, many persons gone.
My lord, since they have already transferred.
And you also transferred 85. Why your name? Your vendor's name will be there.
No,
Basanti's name. I have seen that. It's not that I have not seen. Why Basanti's name will be there in LR record of right?
yes, yes.
Why?
Basanti's name is there.
Why? She have transferred in 1981 to you, whereas they transferred in 1984.
Yes, my lord.
So why not the name of these 2 daughters? Nobody has come forward with CS and RS.
No, CSR is
Then
not produced.
My lord, their main
Only LR.
contention is there is no marriage. My lord, the entire, my lord, this.
Yes, sorry. Hey, hearing concluded. We will rely upon certain judgments on that score.
Quality.
My lord, may I submit one thing? My lord, instead of disposing of this matter today, my lord, kindly allow me one chance. My lord.
No, nothing.
Kindly.
Nothing.
3 days, at least 3 days.
Sorry.
Kindly come back after day after.
No, nothing.
Kindly allow us. My lord, so far, my lord,
Nothing.
so many deeds are
Unnecessarily,
there, my lord,
let's
so
know.
many documents are there. Your lordship, kindly for this.
No, there is nothing.
My lord, may I take your lordship's leave?
Or your lordship, kindly allow to come back. My lord, let me go through the documents, my lord. Thoroughly.
My lord, for it.
My lord, no. We have at a glance. Documents পড়তে হয় আজকে হোক।
Yes. The next.
My lord, kindly, allow me to come back.
No,
My
sir.
lord, kindly let me go through the documents, my lord, each and every documents. Kindly allow me to. Otherwise, my lord, it is troubling me, my lord, very much. Your lordship, kindly.
Let's call the next matter.
But kindly go, let me go through my lord. Kindly. 2 days, my lord.
No.
Let me come back on Friday.
No.
Kindly allow me.
No. এই চলে এসো এখনই ডিক্টেট করে দিচ্ছি। Let me dictate here. We will not grant you. No, definitely.
My lord, kindly, within 2-3 days, my lord.
ये तो এখনই ডিক্টেট করে দিচ্ছি।
Well, already your lordship has already taken trouble to go through the entire matter.
Cannot.
Only.
No.
Next day, your lordship will deliver the judgment.
No, sir. Please do not embarrass me in this regard. Next matter.
I'm 35, my lord, I appear for the respondent.
But if this matter theorized for the appellant, he could not come to court today.
Who?
Theorized for the appellant, my lord.
Last time also, madam, you asked for a time before I went for a circuit.
Maybe that's what, no, that time he was in another court, then he came back.
No,
Yes, yes.
no, it was
But
that he has not come to the, or he was ill. If I correctly remember. My memory is not that
No, no, I'm sorry.
bad.
I also remember Mr.
Second partition suit dismissed. First partition suit up to high court, they was decreed in favor of the plaintiff. They came before this honorable court. After a few days, they withdrew the appeal. They went back to the lower court. Execution was filed, part of the executed. Again, subsequently, they filed another partition suit. Now this has been dismissed again against that.
Cross appeal.
This is a cross appeal, but there are some observations. Cross appeal has been filed.
My lord, I am not briefed in this matter. I know nothing. Only he has informed me that
Not today, otherwise we will not grant you a time. Since he says that he is ill, has not come to court. Next.
grateful to your lordship.
I beg to appear for the appellant.
And who is appearing in 137?
My lord, 137, my lord, was the old matter. My lord, 138, 136 is the matter that is pending before your lordship, my lord. My lord, to cut short the matter, my lord, I have prepared a short written notes. My
What
lord.
is, this is short.
My lord, the judgments are there, my lord, that's fine. It's hardly 3 pages, my lord. I have to copy you. My lord, this relates to land acquisition. Your lordship would kindly take internal page 2 of the
First title, let me take the chair.
my lord would kindly take, this is the admitted list of dates, internal page 2. My lord has found.
Yes, what?
Yes, kindly takes the written notes internal page 2 once. My lord, there are 2 premises, my lord. My lord, the Metro Railway Authority, my lord, was to construct and has constructed the Shambajar railway station, and for that my land was acquired. So there are 2 separate proceedings in respect of 2 separate plots of land. One is before your lordship and the other is not. Now, my lord would kindly takes the admitted list of dates, October 3, 1972. My lord, the suit premises, my lord, the premises in questions was acquired under notification number such and such.
What is that premises?
My lord, that premises is premises number 128. We are concerned with 128. Thereafter, my lord.
128 by 51A, 128 by 51.
Yes, my lord, in a composite manner, my lord, I am saying 128, but there are many premises, 128, starting from 128, 55A to, my lord, there are many premises. It's almost 19 quotas of land.
Yes, then.
So, my lord, I'm referring it as 128.
Yes.
Now, thereafter, my lord, another acquisition was done.
that was in relation to 129.
Yes.
My lord, we are not concerned with that 129 at this stage. Now, in this 129, my lord, an award was passed. My lord, I had challenged that. I had challenged that before the learned land acquisition judge, and my lord, that was disposed of. Against that, my lord, they had preferred an appeal. My lord, the appeal was dismissed, affirming the order of the learned land acquisition judge. Therefore, my lord, in respect of premises number 129, that has attained finality. And the award has been paid. I am satisfied with 129. Now, as regards 128, your lordship would kindly take the order of the land acquisition judge that my lord will find at
Sir,
page.
it's a contiguous plot.
No.
No, 129 and 128.
Yes.
Vidhan Sabha.
Yes.
That is
Now the
what I'm
question
saying.
before your lordship is 128. My lord, there are 3 crossroads, and 129, there are only 2 crossroads. So, my lord, the escalation part is to be considered.
So where they are situated, 128, as you call it,
Yes.
is in the close.
It is in the same locality, but it's quite far. It's in the same locality, but not adjacent premise. Not contiguous, not contiguous, not contiguous. That's my contention with your lordship. Your lordship would kindly take page 35 once. Page 35 of the compilation, my lord. Your lordship would kindly takes page 37. My lord, may I place, my lord, the original order of land acquisition judge, my lord? My lord, decision with reasons. The referring claimant has examined Mr. D.G. Chakraborty, chartered engineer and valuer, who proved his report exhibit 1. The referent claimant also filed the judgment passed by the 5th Special Land Acquisition Judge Alipur in LA case number 11 of 92, exhibit 4. My lord, this relates to 129. Yes. The decree of LA case number such and such, exhibit 5, deed number such and such. On the other hand, the state of West Bengal has filed a certified copy and photocopy of the documents relied upon the acquisition, exhibit A, B, and C. In acquired area, in respect of this, in 19 quotas, 6 chitaks, 19 square feet, and is highly developed solid land, the referring claimant has claimed rupees 2 lakh per quota on average. The valuation prepared by PW1 Sri D.G. Chakraborty shows the valuation at rupees 2,23,000 per quota. As per exhibit 4, additional special land acquisition judge assessed the value of rupees 1,27,700 per quota. The appeal against the said land acquisition 1192 exhibit 4 being FA 233 of 1907 has been dismissed by the Honorable High Court at Calcutta. The premises number 129 Vidhan Sarani, Calcutta, subject matter of such and such acquisition case, had 2 frontage roads, one on Vidhan Sarani and the other Krishnaran Bose Street. The premises in question, this premises, in the present case has 3 road frontages with Vidhan Sarani, Krishnaran Road, Bhupen Bose Avenue. In other words, the impugned acquired has an additional frontage of 100 square feet wide on Bhupen Bose Avenue. Moreover, it is for closer to the 5-point crossing of the Shambazar. Therefore, an appreciation of 20% on the above score may be provided on the blue of 120 Vidhan Sarani, that is on 1,27,700, and the market
129 actually.
My lord, it should be 129. I stand corrected, but it should be 129. And the value works out of at rupees 1,53,240. Thereafter, this breakup is given. The learned government leader has suggested an appreciation on 15% on the value of rupees 1,27,700 on the said score, and the value works out of rupees 1,46,855 per kata. The average of valuation of 1,53,240 and 1,46,855 works out to be 1,50,047 rupees, 1,50,000 per kata average. The point accordingly is disposed of. My lord, against this, my lord, this order was admittedly passed in absence of the requiring body, that is the Metro Railway authorities. The Metro Railway authorities preferred an appeal. My lord, would kindly comes to the judgment of the Honorable High Court. My lord, that my lord would find it starts from page 41. Now, the operating portion, may I place it before your lordship? Kindly takes page 46. Kindly takes page 46. My lord, second paragraph. It was held by the learned land acquisition judge that the land value of the acquired premises belonging to the referring claimant is more than the land value of the other premises my lord has found belonging to the referring claimant, which has acquired earlier, and as the premises now in dispute had 3 main approach roads on 3 sides of the building, while the other party belonging to the property belonging to the said claimant, which was earlier acquired, had 2 approach roads on 2 sides of the building. The London Land Acquisition Judge, while allowing such escalation, also took note of the fact that the acquired premises in dispute belonging to the referring claimant is much more closer to the Shambajar 5-point crossing than the other premises belonging to the said claimant, which was acquired by the government earlier for the said project. Considering the fact that the Metro Railway Authority requiring body satisfied the enhanced award, but that's the other case.
Only question was that
Escalation.
1,27,000 and odd was set at rest, that you
Yes.
can't touch it,
Yes.
nor you can go below that.
Yes.
Only thing is escalation
The
part.
escalation component was
Escalation component depends upon the topography of that particular land.
yes.
And the court has said that it has a 3 access points.
Yes.
And one is a Bhupen Bose Avenue, which is a additional one.
Must.
And therefore, the court, the LA judge must consider it again.
Yes.
In
In
the
presence
light
of them.
The escalation price.
Yes, yes.
Therefore,
Now kindly comes to the impugned judgment and
then it was remanded.
it was remanded.
Then what happened?
Now, strangely, the learned court has declined to give any escalation whatsoever.
Where do I?
Kindly takes the paper book for once. My lord, the impugned judgment, my lord, it starts at page it starts at page 46. And my lord, kindly takes page 50. 50 is the relevant portion. The main question, my lord, may I place it before your lordship? Page 50. My lord, may I place it? The main question which falls for consideration as to whether the referring claimant is entitled to get any escalation upon the land value. On perusal of the case record, it appears that the other property of the referring claimant, then situated at premises number 129 Bidhan Saroni, was acquired by the state at the same time of the acquisition of the present land in question of the referring claimant, and it further appears that the aforesaid premises number 129 Bidhan Saroni is situated adjacent to the present premises in question. My lord, this, my lord, is a perverse finding. On the basis of the land value of that premises number 129 Bidhan Saroni, the land value of the present premises in question was assessed and fixed at rupees 1,27,700 per kata by the learned special land acquisition judge. In order to get any
The division bench has categorically said that you'll have to decide an escalation. Why the court has refused to decide an escalation point? Because the division bench also said that there is an advantageous position. The third connecting road is also there. And that ought to have been taken into consideration. That was a specific finding of Justice Jyotirmoy Bhattacharya. And here you say that they have failed to prove that it has advantages, when the division bench says it has an advantages.
Stated in the
Can you go by this?
They could not produce any document before the court.
Is it necessary? What was the finding of the division bench? That finding is conclusive. The division bench has in a very close terms said that the learned acquisition judge, while allowing such escalation, also took note of the fact that the acquired premises in dispute belonging to the referring claimant is much more closer to Syam Bazar 5-point crossing than the other premises belonging to the said claimant, which was acquired by the government earlier for the said project. Considering the fact that the Metro Railways requiring body is satisfied, the enhanced award passed by the land acquisition judge in respect of the other premises belonging to the said claimant, this court is of the view that the Metro Authority is now stopped from challenging the correctness of the assessment of land value at rupees 1,27,000 by keeping parity with the land value assessed by the land acquisition judge in respect of the other adjoining premises belonging to the same claimant. Thus, the scope of challenge this appeal in our view is very limited. The appellant at best can challenge the legality and correctness of the escalation part, which was allowed in present case against the claimant of 20% escalation. Thus, we feel that the land acquisition judge did not commit any illegality in accepting the value of 127 per kata as a requiring body. Valuation is per kata. As such, we hold that the part of the finding of the land acquisition attained finality, and it is also building upon the requiring body for the reason as binding upon the requiring body. That is the wrong word. Thus, the requiring body is stopped from challenging. Now, however, by taking note of the decision of the Supreme Court as referred to above, we feel that the reference case may be sent back to the land acquisition judge on demand for fresh consideration of the issue relating to escalation part, which was allowed by the land acquisition judge, taking into consideration the favorable situation of the property acquired in the present case. We thus confirm the correctness of the selection of such and such. As such, this part of the dispute between the parties cannot be reopened at the time of consideration of the reference. Land acquisition judge is thus directed to reconsider the escalation part which was allowed in the present case in presence of the requiring body. We thus direct to implead the requiring body. However, such and such hearing is to be done. Requiring body is permitted to adduce evidence. Now, is adduce evidence in support of the claim that under objection in this proceeding, and it may also examine its own witness and cross-examine the witness in adversaries. Similarly, in case of an evidence adduced by the requiring body, the referring claimant will be permitted to cross-examine. What more?
Observed by the court below that they could not produce a single paper before the.
What single paper is required escalation?
They also did not lay any evidence.
The referring claimant in instant case did not file any scrap of paper/deed and a document to substantiate that property situated far away from the 5-point crossing.
Sir, there was a survey report. Valuer was there. Valuer has indicated everything. His evidence was taken into consideration, where he has indicated that what is the advantages which this particular property has in comparison to 129. You did not cross-examine that witness. You did not adduce, despite the liberty being granted to you. What more? Onus was upon you.
And come once again to page 49
49 of
the paper.
yes, please.
Our argument from learned advocate of the appellant with reference to the escalation matter submitted that valuation of another property situated in the interior area and
In the interior area.
and far away from the 5 points crossing of Shambhajar was acquired by the government at the same point of time was assessed at rupees 1,27,700 per kata.
Correct.
Accordingly, the valuation of the property of the referring claimant acquired by the Metro Railway Authority, which is located on the 5 points crossing of the Shambhajar, should be higher than the valuation of the aforesaid another
That
property.
is there.
Yes, my lord. According to him, on the basis of the aforesaid comparison, appreciation of the valuation should be allowed in favor of the referring claimant. At the same time, the learned advocate substitute that what will be the rate of escalation, that will be the discretion of the court, since there is no approved checklist or rate to that effect. On the contrary, learned government leaders subjected to this court that the referring claimant ought to have containment of escalation by producing both oral and documented evidence. But he did not do so. The referring claimant failed to prove that really escalation is needed, and as such, the referring claimant is not at all entitled to get any escalation above the valuation of land to assist. Learned advocate for the Metro Rail Authority contended that comparing with the valuation of another land then acquired, the valuation of the present acquired land was assessed by the learned special village judge, and that valuation attained finality by the observation of the Honorable High Court passed in FA number 249 of 2011. According to him, referring claimant failed to prove the need of escalation according to law. Now I am to consider the materials on record to have a just decision over the point of escalation in compliance with the direction of the Honorable High Court. The main question which calls for consideration as to whether the referring claimant is entitled to creating about the land value. On perusal of the case record, it appears that another property of the referring claimant, then situated at premises number 129, acquired by the state at the same time of acquisition of the present land in question of the referring claimant, and it further appears that the aforesaid premises number 129 is situated adjacent to the present premises in question. On the basis of the land value of that premises number 129, the land value of the present premises in question was assessed and fixed at rupees 1,27,700 per kata by the special land acquisition judge. In order to get an escalation of price, it is the duty of the referring claimant to prove that the present premises in question had more advantage than the another property, and the present premises in question had more utility than the another property of the referring claimant then acquired. Referring claimant in the instant case did not file any scrap of paper/deed document to substantiate that property situated far away from the 5 points crossing of Shambhajar was acquired and valued the same rate of 1,27,700 per kata at the same point of time. Referring claimant could not establish any rate to be followed by the court to consider the escalation method. It is admitted by the learned advocate of the petitioner that there is no formula for coming to a conclusion regarding the rate of escalation of the acquired value. Without any structured formula, without having assess the escalation, without comparing with the deed or document of the other property acquired at the relevant point of time, which is situated adjoining to the property in question, it is very difficult for this court to come to a definite conclusion that there is a need of escalation or appreciation of the valuation of the land in question valued at rupees 1,27,700 per kata. Thus, in view of the aforesaid observation, the only conclusion that can be arrived at by this court that referring claimant has failed to prove his demand of escalation of the valuation of the land in question. But it is observed that they fail to produce any.
Is it necessary, madam? Question is that in an earlier round of litigation, if the court has already come to a finding, and it is only the quantum of escalation which is to be assessed.
Regarding quantum,
Now,
they have
you were permitted to adduce evidence because the onus lies on you. Why the judgment of the LA judge was interfered in an earlier round is appearing at page 43 when you took a plea. That section 18 of the Land Acquisition Act says that in the event the appeal or the reference under section 18 is decided by the LA judge, the presence of the requiring body is mandatory. You cited 3 judgments of the Supreme Court, and therefore the court says the question which is raised in this appeal by Mr. Basu, learned senior counsel at page 43, is as to whether the assessment of the valuation of a land acquired by the land acquisition judge in absence of a requiring body is permissible in law or not. That was a question. The answer to the question, then the court says, is no longer res integra in view of the several judgments of the Supreme Court. Then UP Awas judgment was considered, Kanak was considered, and then the Bholanath Sharma's judgment was considered. And the court says that your presence is important. In your absence, it cannot be done. And on that score, the court says, set aside. You be there and you were permitted to adduce evidence. And the onus was on you when the court says. Court has recorded the land acquisition judge, while allowing such escalation, also took note of the fact that that is at page 46, that the acquired premises in dispute belonging to the referring claimant is much more closer to the Shambajar 5-point crossing than the other premises belonging to the said claimant, which was acquired by the government earlier under the said project. Then it says that you were satisfied that at 127 the price is good. Then the court says that we do not find that the land acquisition judge has committed any error in 127, that figure. Then it says, however, taking note that you were required to be implemented as a party and to be permitted, says that consideration of the issue relating to escalation part, which was allowed by the learned judge by taking into consideration the favorable situation of the property acquired. We thus confirm the correctness of the selection of the basis of the calculation of the valuation at 127. And then it says, as such, this part cannot be reopened. Then it says the learned acquisition judge is directed to reconsider the escalation part, which was allowed in the present case, in presence of requiring body, you. We thus direct the learned judge to implead requiring body, suo motu. Referring claimant is thus permitted to participate in the said proceeding at the time of hearing of the said reference case in the light of the observation. It is made clear that the requiring body will be permitted to file its objection. You did not file. In connection with the said proceeding within 4 weeks from date. The requiring body is also permitted to adduce evidence in support of its claim under objection in the said proceeding, and it may also examine its own witness and cross-examine the witness in adversity. Similarly, in case of an evidence adduced by the requiring body, in connection with the said proceeding, the referring claimant will also be permitted to cross-examine. What does it mean? But you did not adduce evidence. So the filing objection does not mean proof. Only thing is, ও ছিল না বলে opportunity দেওয়া হলো আর তুমি adduce করো evidence. And এখানে LA collector এখানে তো আছে finding টা বলেছে যে he was কি বলছি valuer was appointed. Earlier. It's appointed. DG Chakraborty, DG PW1. He's a valuer. Did you file the judgment of the High Court in that 11th? Did you file that judgment?
No, my lord, that I could not.
No, you have judgment of 11 you have
Yes,
given.
that I have, that I have.
Where is that?
Page 5 it starts.
5.
Page 5 of the written notes.
Where is your pleading? Did you incorporate that in a paper book?
Yes, my lord, kindly takes my written notes of argument that was submitted.
No, not written notes of argument. We wanted that.
My lord, so far as this application, my lord, under section 18, that page 30. I will say it's no, my lord, may I? May I? My lord, may I bring?
Yes.
May I bring to your lordship's notice one interesting fact, my lord? Your lordship would note, peruse, my lord, the earlier order of the land acquisition judge. There, my lord, 15% and 20% on an average, the escalation component was fixed. If my lord goes to the original order of the land acquisition judge, my lord, after the order of remand, my lord, we have stated that we don't seek 20%. We are happy with the average that has been already determined by the land acquisition judge earlier. That we have submitted before the learned court. Kindly takes page 42 once from the paper book. Page 42, paragraph 5. It is pertinent, my lord has found. We have foregone the claim of 20% escalation. And Therefore, my lord, all that was open. My respectful submission before your lordship is that they had to bring on evidence before the learned acquisition judge as to why this finding was bad. Why?
No, I'm really looking into it because I do not find that evidence of PW1.
My lord, so far as the evidence of the PW1, my lord, what has happened, my lord, we checked the lower court records. My lord, from the lower court records, I noticed that, my lord, the entire records are not there. The evidences are not there. My lord, I have seen that. Kindly takes the lower court records once. একবার ওই বড় ফাইলটা দেবেন আর ওইটা দেখো একটু দেবেন তো আমার ওই পার্ট 2টা কোথায় আছে আরেকবার ওইটা
দাদা এখানে দাও I can
ওইটা একবার my lord will find that they were given an opportunity to give evidence. They have
earlier prior to this the evidence was taken.
evidence was taken, but that is not in the record.
That is what I really wanted.
No, that is not on record. That could not be traced. এটাতে কোনটা আছে
The remand, it has gone.
বাজেটটা দিল পরে বাজেট কয়েকটা
After remand, it has gone.
ফাইল ফাইল টু যেটা ফাইল টু
না আগের রেকর্ডটা দেখো তো এটা নয় এটা তো after remand it has gone. Before remand where is
So before remand, my lord will find there is an order to that effect for reconstruction. My lord would kindly take the order date 19th of April 2005. এটাই তো অ্যাপ্লিকেশনের সঙ্গে দিয়েছে দেখুন my lord না এটা হচ্ছে এর আগের অ্যাপিলে মেট্রো রেলওয়ে যেটা জমা দিয়েছে মেট্রো রেলওয়ে ডকুমেন্ট ছোট্ট ঢাকা পার্টনারের the records, my lord, are not there. And my lord, may I just, my lord will find item number 137. That is the other appeal which was disposed by Honorable Justice Jyotirmoy Bhattacharya. My lord, in that, my lord, the Metro Railway had submitted a map. My lord, my lord, may I place it before your lordship for your lordship's kind perusal. Kindly takes it. এটাই তো এই মনে তো এটা ওই দিক থেকে দিয়ে দেবো জজ সাহেবকে এইভাবে খুলে দিন My lord, this is the map given by the Metro Railway authorities. May I just place it before your lordship? Yeah. My lord, this is the map of the railway authorities, the requiring body. My lord will find that this present premises is situated in a much more lucrative position, commercially much more lucrative position. My lord, they did not come up with any single paper to dispute the finding of the earlier order, which was affirmed by this honorable court.
This is 128.
Yes, 128. And my lord will find 120, 128, my lord, there are 3 roads. And there is already a judicial order recording this fact. Relying on exhibit 1, my lord, there is already this order. My lord, if it is not there, my lord, my lord, we have taken out an application seeking can 4 of seeking additional evidence, my lord. My lord, I will be beseeching if your lordship would kindly set aside the order impugned, my lord, and since we have foregone the escalation so far as 20% is concerned, my lord.
They say not even a single penny on escalation.
My lord,
They are saying not a single penny on escalation. They have not accepted 15%.
but they have to give by way of evidence. Now, my lord, kindly takes
A different issue.
my lord, kindly takes my lord.
This is where that's their application. It came here in the High Court.
Yes, yes, yes,
In the High Court, they have filed.
yes. In the earlier my lord, may I just
You are not a requiring body. No. Don't argue. You have nothing to say. They are the requiring body. You are acquiring body. You are simply a facilitator. Money will come from them. You will simply pass on to him.
my lord, the learned trial court has come to a perverse finding that there is no structural formula, but my lord, the base value has already been fixed. 1,27,700 has already been fixed. My lord, burden lied on them.
একটু সাবধানে দেখে তো।
My respectful submission, burden lies on them, my lord. The Honorable High Court directed that it should be disposed of in their presence, and if you are disputing it, then you come up with proper evidence. My lord would peruse the orders, my lord, there, my lord, they were given an opportunity to lay evidence. They did not. No, I'll be placing that order.
Yes, yes, take your seat. Now let us hear. Forget about it. Forget about it. Now question is only on the point of an escalation. You were permitted to adduce evidence. You were also permitted to cross-examine if their witness is already examined. They already examined the valuer. The valuer submitted the report. The report was accepted and marked exhibit. The moment the report is marked exhibit without any objection from your end, then the content of that report should also be accepted by you. Is it not? If the content is also accepted, then one has to look into the content. That report is here in the paper book. If that being the position, it is an admitted because the LA collector has said that is the PW1 has exhibited, given evidence and the report was exhibited. And if the report says that this is a additional advantage which this land has, having 3 access points, then can you controvert now? Can the court say that there is no evidence at all in this regard? Can it say so? I'm asking. Very simple question. He says there is no evidence. There is already an evidence. If he has not looked into it, then what? Is it not a perverse finding? Non-consideration of the material evidence. The valuer was called. Valuer says who has gone at the spot and has made a sketch map and has given it. And has said that what is the advantage? What more evidence? He said field inspection. I have gone there and I have inspected. Why I say so? Come to page 16 of the paper book. 1-6. Very opening sentence. Very opening sentence at the top. When I say opening sentence means at the top. You did not cross-examine that witness. Record does not say you did not use that evidence, nor you cross-examine this witness. Nothing. You did nothing. That is what I say, that it goes uncontrolled. Record is very straight. Nothing will transpire there. Everything depends upon the finding returned by the judge. Record has gone, destroyed. Reconstruction could not be done. That cannot be done at this juncture. How they will prove? Kindly visualize. Kindly visualize. There is nothing. Only thing is how they can prove that it has got a more advantageous position. It is in a more advantageous position in comparison to a contiguous plot. How? How they will prove? They can only prove by way of a field inspection, appointing a valuer who has gone there physically, made a plan, and then say it has a 3 access point. You did not controvert it. You did not cross it. It goes uncontroverted. What more evidence is required? And he can't take up the brief for you. He is for the state. He can only support the stand of a LA collector as a state. which that right has taken away by a earlier division bench judgment. That right has been taken away. So he can't reopen that issue, nor can argue that. What more? Can't be done. So now what to do? It has to go back again.
My lord, may I respectfully submit again? It will. My lord, since 8. My lord, we have filed an application seeking under Order 41 Rule 27. My lord, we will not be pressing that application. My lord. Will not be pressing. My lord, would kindly takes page 42 and page 43. My lord, we have given a detailed calculation.
Of adversities. Reduced by the requiring body, referring to तो तुम्हारे तो इसे प्रोसेस जरूर करा उचित which you did not.
My lord, since 1972, my lord, we are battling. My lord will not kindly remand it. My lord, since 72, we are battling. My lord, we have foregone the 20%, my lord. Whatever the average that was fixed, my lord. My lord, again.
No, only I tell you very frankly. We are of the firm view that there was an evidence on record with in relation to that particular advantages which this plot has in comparison to the other. We are absolutely convinced. Since you did not, we have also seen the observation of the division bench decided over by Justice Jyotirmay Bhattacharya. There says that you go file an objection, whatever witness, you cross-examine them. You did not have it. Then say, if you chose to give an evidence, then they will cross-examine. You did not. So you foregone both the rights. So this goes uncontroverted, this goes unchallenged. It has to go. Now question is 15-20, how it is to be arranged. Even if we remand the matter, what should be the parameter? Because both the courts have said there is no fixed parameter. Then the assessment on the basis of the valuer has to be accepted. And valuer says 20%.
Yes, I have foregone that.
They have foregone 20%. So we'll say 15%.
No, my lord, would kindly takes page 42 once. My lord, we are saying the average rate that was already determined by the land acquisition judge. That we are accepting it, my lord. Kindly takes once.
You can't.
No, kindly takes.
You can't approbate and reprobate at the same time.
No, kindly takes. My lord, it is may just place once.
No.
For once, my lord.
Nothing.
For why satisfy? Kindly.
Nothing.
Page 42, paragraph 5. First, second, third, fourth, fifth. Seventh line. It is pertinent to mention that the referring claimant had decided to forego their claim of 20% escalation and acquiesce to the rate escalation being average rate of 15 and 20%, resulting in the rate of rupees 1,50,000 as decided by the land acquisition judge in order dated such and such.
15% on 127. That's all.
Or 15.
Only 15%.
No, we say average. Kindly.
Only 15% on 127, not more than.
Since 1972, we are battling, my lord, even before we were
Getting that particular interest from 1972.
Well, let it be 15%, my lord. Let it be 15%. Kindly not remand it back, my lord. It will again. Will not remand it, my lord. That's my humble prayer.
It's the second time when the appeal assailing an order of the land acquisition court is filed at the behest of the metro railways within bracket requiring body assailing the this is a it is may I at the behest of the claimant assail at the behest of the claimant the admittedly the premises number 128 by 51A to 128 by 55A Vidhan Saroni, comma 128 by 13A to 128 by 23A, comma Vidhan Saroni. One 128 by 51B Vidhan Saroni, comma 128 by 40A plus 2 128 by 50A Vidhan Saroni, comma 1 by 4A and 1 by 5A Krishna Ram Bose Street was acquired for construction of a mass rapid transit system and other connected works relating to the metro railways running between Damdam to Taliganj. The notification under section 4 of the Act 1 of 1894 was published on 3/10/1972. No, was published on 5/10/1972. And the declaration was declaration under section 6 was published on 3/8/1979. since it was for a public purpose, and there was no dissent in this regard, the land acquisition collector assess the compensation in respect of the aforesaid premises. Since the petitioners did not accept the valuation arrived by the land acquisition collector, an application for a reference under section 18 of the said act was taken out, and the matter was ultimately sent to the LA court for determination of the market value of the property and the other statutory entitlement under the aforesaid act. The proceeding, the reference case, which was registered as LA, what is this? LA case number
59.
59.
59 of 1992.
59 of 1992. You will listen. Was allowed to be proceeded with by the LA court, and invited the petitioner to adduce evidence in support of the claim. As a matter of record, it is important to note that the proceeding was allowed to continue in absence of a requiring body, that is the Metro Railways. The petitioner, the appellant examined examined Mr. D.G. Chakraborty, the chartered engineer and valuer, as first witness to corroborate and prove the report submitted by him, not only the ascertainment of the value, but also on the topography of the land being the subject matter of the aforesaid case. Ultimately, the said report was marked Exhibit 1 without any objection from the state. This said case ultimately came up for final disposal on 29 September 2001, wherein the LA court opined and observed that the land, which is the subject matter of the said acquisition proceeding, has a more advantages because of 3 roadside road frontages some of which is nearly 100 feet wide, and is situated more closer to a 5-point crossing of the Sambajar, which is one of the prime locality of the city of Calcutta, not only in relation to the commercial activities, but several other activities. It further revealed from the record that another property being 129 Vidhan Saroni belonging to the present claimants was also a subject matter of acquisition for the said project, for the said purposes, and a compensation was and the market value was determined at rupees 1,27,700 per kathas. And the said order of the LA court was affirmed up to this High Court. It was thought to be contended that the subject property, which has more advantages than the aforementioned property, wherein the market value was assessed at rupees 1,27,700, should be assessed more. Full stop. The LA court, on the basis of the report submitted by the engineer cum valuer, held that the claimant is entitled to more amount than what was assessed for the other property of the claimant. Interestingly, the learned government pleader suggested that an appreciation by 15% on the value of 1,27,700 may be awarded, and therefore on the basis thereof, but the report of the engineer indicates that there should be an escalation to the extent of 20%. However, the court took an average of 15% to 20% and arrived at the conclusion that the value of the acquired land at the relevant point of time is 1,50,000 per katha, 50 per katha. The said judgment was assailed before the division bench of this court in FA 249 of 2011 by the Metro Railways within bracket requiring one, solely on the grounds that in a reference case originating under section 18 of the said act, and any determination having made therein is bad in law, having decided in absence of the requiring body. Solely on the ground that the requiring body ought to have been added as a party to the said proceeding and should be given an opportunity to defend the said reference case. The judgment of the LA collector was LA court was set aside, and the matter was remitted back to the LA court to take a fresh decision on the escalation part only. The division bench categorically observed that the valuation at rupees 1,27,700 per kata remain affirmed, and the LA court shall not revisit its decision thereupon, but restricted the considerations on the escalation part with the rider that in the event the requiring body chooses to contest, it may cross-examine the witness of the claimant, and in the event chooses to adduce evidence, an opportunity to cross-examine the witness by to the claimant was also provided. Next paragraph. Interestingly, the requiring body, after being impleaded as a party in the said proceeding, filed the objection, but did not adduce any evidence, nor made any prayer to cross-examine the witness examined by the claimant in the said case. Astonishingly, the trial court, the LA court rejected the claim of the petitioner, restricted to the escalation part on the ground that the claimants have miserably failed to prove by cogent evidence that the acquired land, being the subject matter of dispute therein, is situated near to a 5-pied crossing at Shambazar, or have a 3 road frontages. The aforesaid finding cannot be sustained for the reasons. Now, for the simple reason that the engineer come surveyor, engineer come valuer was cited as a first witness to prove the report submitted by him in respect of the subject properties. The said report was marked Exhibit 1 in presence of the state, but obviously in absence of the requiring body, as it was not impleaded as party at the set relevant point of time. The observation of the division bench was categorical, being alive of the fact that the witnesses have been examined by the claimant to provide an opportunity to cross-examine such witness. Stop. The moment the report is marked exhibit without any objection, and despite the opportunity having given to cross-examine the said witness, the same having not availed of, the report goes uncontroverted. And the moment it is marked exhibit without any objection, the contents have to be understood and considered in this regard. Now, considered as having proved. It is expressly indicated in the said report that the plots being the subject matter of the instant proceeding enjoys 3 roadsides, that is Bhupen Bose Avenue, Bidhan Sarani and Krishna Ram Bose Street. The valuer adopted the belting method separately because of the aforesaid advantages which the said plots enjoyed, and ultimately arrived at the conclusion that the base price which was fixed for premises number 129, Bidhan Sarani, being the subject matter of the other acquisition proceeding, cannot be similar and identical to the plots being the subject matter of the instant acquisition proceeding. Since the evidence of the first witness of the since the deposition of the first witness of the claimant goes uncontroverted, as no cross-examination was done, nor an opportunity given by the division bench was availed of, we do not find any justification in the stand of the LA court that the claimant has failed to prove that the subject plot had more advantages than the advantages enjoyed by premises number 129, Bidhan Sarani, Kolkata. So far as the escalation part is concerned, the valuer has suggested 20% escalation over and above the rate per kata determined in respect of premises number 129 Bidhan Sarani. But at the time of argument, the learned advocate appearing for the appellant submits that his client is ready to forego the above and may squeeze their claim at 15% escalation. In view of the above, and the fact that the subject plots have an additional advantages, not only having 3 road frontage, but nearer to a 5-point crossing, we therefore award a 15% escalation over and above rupees 1,27,700 per kata. Full stop. In view of the findings made herein above. No, only thing is from this state it should come. The claimant is entitled to an award, to get an award of rupees. The calculation key, please give 127,700 and 15%. Give a mathematical calculation.
1,46,000. 1,46,855
Per katas.
per kata. 15%.
Hmm.
1,466.
For the quantum of the lands acquired over and above. Full stop. The claimant is also entitled to get a solatium at the rate of 30% with respect of the entire value of the land. The claimant is also entitled to an additional compensation, additional statutory compensation at the rate of 12% per annum. On the entire land value and the value of the structure from the date of the publication of the notification till the date of the award. The claimant is further entitled to an interest on the entire compensation at the rate of 9% per annum for the first year from the date of the position, and thereafter at the rate of 15% per annum till the entire amount is paid. That's the only thing. The entire amount shall be paid. It is, however, made clear that upon arriving at the calculation in terms of the above order, the amount which has already been paid to the petitioner shall be deducted therefrom.
take actually with interest.
Amount deposit is calculated. সেই calculation এ amount was deposited. সে বেশি থাকবে বেশি থাকবে
How much you have received?
We have got rupees 24 lakhs 24,514.
How much?
Did we
No, no, how can you deposit it? Because their claim was dismissed. That was on the basis of 127. They did not pay any amount.
May I just indicate your lordship? Kindly takes your lordship the order dated October 5, 2021.
Yes. October? Yes.
Your lordship, we have till date taken rupees 24 lakhs and odd and 1 crore 52 lakhs and odd.
The आगे repeat it. The आगे repeat it.
ও বলেছে
Complication nothing minus simple. Yes, কি বলেছি? And while calculating, deduct the amount already paid.
We have not received the balance amount. It is still lying with the register.
We are giving you liberty to take that. Yes, কি বলেছি? And after while কি বলেছি? The amount land which is already deducted therefrom. It further appears that a considerable amount has been deposited by the respondent before the Registrar General of this court, while the earlier appeal was filed before this court. The said amount is still lying with the Registrar General, and therefore a prayer is made that the same may also be adjusted.
7 September 2022, we have already applied.
কি বলেছি? No, the prayer is made that despite an application for withdrawal of the amount, comma, the same has not been released as on date. We therefore direct the Registrar General to expedite the said application filed by the respondent, that is the metro authorities, on 7 September 2022, and shall see that the same is disbursed to the respondent within 2 weeks from date.
May I make one last innocuous prayer, my lord? My lord, let the money be disbursed within a stipulated time frame, my lord. Only that. Lord, kindly, my lord,
Execution.
my lord, it kindly stipulates, my lord. Only 3 weeks are left, my lord, before puja, my lord. Kindly. But it's already lying with the